Am I audible, court officer? Court officer?
ಹೇಳಿ.
Audible ಇದೆ ಅಲ್ವಾ ಮೇಡಮ್?
ಹೌದು.
Okay, thank you.
Lordship, with your permission on submission to make. Lordship, its Lordship has given 1 week time for me to convert the file from RPFC to read petition. 1 week got over and still the file has not come to pending.
Find out what it is.
Sir, N. Kumar Sahib, sir, nimdu disturbance nodi.
Yes.
One matter for orders minute. Arrest warrant is issued against the husband. The wife has given a let IA for seeking the arrest warrant. In this minute, the arrest warrant is issued.
Give it, we will see. Yes.
I have for early hearing I filed, my lord. The husband is not paying maintenance.
Which year is the writ petition?
My lord, it's a 2023 writ petition.
It will come next week someday.
Yes, my lord. Wait for me.
Next week will
Call,
My lord,
page by
lease to serial number 27. Kindly lease the matter to 7-8, my lord. As the same parties have other two matters on.
she'll call the list. Wait for it.
page
She'll
wise
call the page wise adjournments.
page wise adjournment, list 1, page 3, serial number 7, page number 4, serial number 8 to 12, page 5, 13 to 15.
Serial number 13 and 15, my lord. Mr. B.S. Umesh is not in station. Some personal convenience. Kindly have it Monday or Tuesday.
Before the
13 and
15 and 16.
what to do? These many matters, how it can be adjourned? Court is taking MFAs on a Thursday. Is it not
kindly pursue
inconvenient
the
to
order
the?
sheet, madam.
Huh?
All the 6
We will see. When the matter is called, we will see. We will not allow like this. Yes, next.
Page number 6, serial number 16 to 18, page
Lord,
7.
serial number 18, madam. I represent the appellate. The claimant's council's housewarming is there today. We taken up any other day.
So many matters.
I'm ready. It's all on quantum, madam.
What happens is, like, that's what you can dispose of. Problem is, court is taking up this MFAs only on Thursday.
Yes.
If adjournment is sought, then it's at the risk of parties.
But he is unable to come.
When you want.
Any day.
This is the matter next Thursday.
Page number 8, serial number 19 to 21, page number 9, 22 to 25,
Serial number 23, ma'am. I am for the appellant claimant's appeal. I'm not well, madam. Next week, madam.
Inform the other side
Ashok and Patil,
next week at the request of front counsel, the appellant.
list number 2, page wise adjournment, page 4, serial number 15 to 17,
Serial number 17, my lords. I filed my NOC Wakalat today in the office and I'm filing a memo for withdrawal of the petition, my lords.
withdrawal.
You already filed your NOC Wakalat.
Yes, ma'am.
Memo is filed seeking to withdraw the petition. Dismissal is wrong. Yes.
Please, madam.
Page number 5, serial number 18 to 23, page number 9, 24 to 30,
My lord, serial number 29, my lord. I am for the respondent. I seek 2 weeks adjournment, my lord. Matter has been settled between the parties. The petitioner has to come from Hyderabad, my lord. Therefore, 2 weeks time may be granted. It is already settled, my lord. We have informed to the petitioner also.
He submitted that the matter is already
29.
settled between the parties. But filing a memo, counsel for the respondent seeks time. This is matter on 21st. Yes.
27, my lords.
page number
Kindly lease the matter to 7-8 as the same parties have other two matters on the 7-8.
But I only have one request. I appear for the petitioner in that. Today is the execution day where they're pressing for issue of warrant. If they don't put out till 7th, then I have no objection.
So shall I pass an order saying that till that day you will not precipitate the execution?
I'm paying interim maintenance also.
As per the last order of this honorable court, my lords, no complaints has been further.
It is compliant now. You come when the matter is called. Ask your senior to come, or you are on record.
No, ma'am.
Ask your senior to come. Yes.
page number 7, serial number 32, 33, page number
Serial
8,
number 36, my lords. Serial number 36, my lords.
38, 34 to 42.
Yes, 36.
Serial
Next
number
week, my lords, 5th case, my lords, I have to file an affidavit in that case, my lords.
Where is the counsel for the respondent informed?
Notice to respondent has been held sufficient, my lords. He is not appearing, my lords.
When do you want?
5th, my lords.
Yes, at the request 5th.
serial number 31, my lord. 31, my lord. I appear for petitioner, my lord. 6 or weeks time, my lord, that matter is going on to be settled, my lord. Parties are talking.
Inform the other side.
I am informed, my lord.
No, you have to inform, then only mention or else when the matter reaches. Yes.
I appear for the respondent
In
in
which
31, my lord.
31.
In which case?
31, my lord.
31, they seek adjournment.
I will fix for 1 week time, my lord.
1 week time, yes.
A week's time. Give the date on the next week, basing on the list.
A date may be fixed, my lord.
Yes. Yes, thank
Page number 8, serial number 34 to 42, page number 9.
My lord, I'm serial number
43 to
42. I'm seeking 1 week
42.
adjournment. I have informed the others.
What is the reason for
Serial
adjournment?
number.
Senior is not feeling well.
When do you want?
Any date, maybe next week.
List the matter on 13th of August.
Date.
Serial number 43, my lords.
43 to 50.
Serial number 43, my lords. Next week, my lords, 7th.
Inform the other side.
I'll inform. I'll inform, my lords. I'll inform, my lords.
Oh, I will. You have to inform and mention. If not, wait for your turn. Yes.
Serial number 45, my lord. Serial number 45, my lord. I appear for petitioner. Any short date, my lord. Short accommodation, my lord. I have some personal inconvenience today.
I said, have you informed?
I inform, my lord. I inform.
No, I will. That's what I'm telling everyone. Wait for the turn. Yes.
Any short?
Short also without not informing the other side. Yes.
Page number 51 to 54.
My lord, third list, my lord.
Third list, all the matters referred
Serial
to the
number 8 is
Lokadala.
claimant appeal for liability, my lord. Serial number 8.
Serial number?
8, my lord. Can you release
Serial
or no?
number 8, delete from the list. Yes.
Serial number 46.
Kindly list of 15th 8, my lord. 15th 8. Next month.
We'll see. We will see. Yes, they are
My lord, one
listed now
submission.
only for reprieve.
My lord, serial number 54. We are filing memo for withdrawal, my lord. The matter has settled to
4.
Yes.
In the third list.
Yes, ma'am.
A memo is filed stating that the matter is settled. They want to withdraw. Accordingly, dismissed as required.
Serial number 18, my lord.
Serial number?
18.
18.
This contributed negligence, 40% deduction, my lord, more than 7 lakhs.
18, delete from this list. Yes, next.
Serial number 46, my lord. In the last occasion, the matter was referred to Lok Adalat, my lord. The parties are not willing to settle the matter.
Yes, 46 also delete.
46
Six,
and
yes,
65 also.
also to be deleted. By the 65 also.
So, yes, my lord.
Yes, 65 also delete. Yes.
My lord, in list number 2, serial number 33, my lord, the counsel for petitioner has some emergency. So he's sought for time, my lord. Today it's not possible. Any other date in the coming week?
What about the respondent? Have you informed them?
No, I have not. I have no idea.
We'll wait. We will wait. We don't know what is their urgency. Then we will not pass any.
Yes, my lord.
We'll consider that time. Yes.
List number 1.
My lord, it's informed, my lord. The respondent is informed.
34.
34.
33.
33. Yes. The request of learned counsel for the petition. Next week it is submitted that they've already informed to the learned counsel the respondent. Yes.
Lordship, list number 2, Lordship. I was held up in another court. List 247, Lordship. I'm for the petitioners. I've informed the other side. I seek for a short accommodation.
You have informed or you will?
It is already informed, Lordship.
Why you want adjournment in 25 matter?
A senior is out of station today, Lordship. A date may be given. I will finish it on the next.
What happens is all adjournments, again dates given, that day already date matters are there. Difficult, simple matters, senior's presence is not required for this. This is matter on 20th.
47.
Grateful, 47.
Yes.
Grateful, Lordship.
Yes.
List number 1. Parted matter, serial number 1. Manohar N for petitioner. Vijay Shekhar Gowda.
Yes. Where is impugned order? Page number. Where is impugned order? Page number.
Annexure H, page 73, my lord. This is that during the pendency of the divorce petition filed by me, husband. Section 24 of the Hindu Marriage Act. The application was heard and passed in order.
What is the income of the husband?
Led, the husband petitioner herein is a taxi driver. Led,
Yes.
they are togetherly, they are happily, they are living together before, after the marriage. 2 children was born. Thereafter, my lord, she has had some illicit relationship with respondent number 2.
Yes.
I came to know that this incident, then my parents came to know that, and they are filed suit against us, both of us, to dispose us from the premises where we are together living with the parents.
Yes.
And she went out of the house.
Yes.
And she is living with the respondent number 2. Thereafter, I also, because of my parents who filed a suit against me, I went out and I'm living in rented house with my 2 children. I'm looking after. I'm the taxi driver. Thereafter, my lord, I filed a suit. The matter is pending before the family court, and I led evidence. I already led evidence in the year 2022. The respondent did not cross-examining.
Yes.
And in the meantime, I filed an petition GNWC. It was in the same court, my lord. It was heard and disposed of in my favor. It's the children are, it's with my custody. Under the Annexure E, page 41. The same court had decided ex parte.
No, you are enjoying a blanket order from 2023.
Yes.
No condition, no amount to be deposited, right from 2023.
Not necessary. It is not the question of, my lord, it is not, she is asking for food or shelter. She is living with someone else without living with me as a wife, and without looking after the children. It is absolutely, it is illegal, my lord. It is not the question of she is begging for money or something. It is for livelihood, for food, for shelter. Definitely, Supreme Court has said I am the obligation as a husband to look after the wife during the pendency of the case. Not this kind of her character, my lord. And it is admitted fact that DNWC has passed an order in my favor, and custody of the 2 children I am looking after, and I am.
Is it correct the custody is given to them?
Absolutely.
Given to him?
No, Your Honor, if he produces one document to show that my client is residing with respondent number 2.
Not about, I asked you a question, whether the custody is given to the father?
No, it is, that is, when the case was pending, he filed GNWC. He has taken ex parte order to see that someone should be served to some other person. And he obtained ex parte order. I have filed miscellaneous petition. It is pending before the same court.
Oh, children are with whom?
Children with father has taken forcibly by order of the ex parte order. He has taken away custody.
When was the order in GNWC?
GNWC.
Annexure H.
Annexure H. He has produced everything, Your Honor.
Date?
GNWC. Maybe it is after 2022, after filing of this petition, our writ,
During the pendency of the
during the pendency of MC.
I'm asking for a date. Both
date,
of you are not able to date.
5th of February 2022. Annexure E, GNWC 199 of 2020. Page 41. In the MC petition, I have already led in evidence. I produced the documents, what have documents have marked, same marked, I have produced.
It's an ex parte order.
Yes. Well, in the same court, she was very much known the facts of the case. She is very much aware of both the courts, both the cases.
Yes.
And Millard, kindly see the impugned order, section 24, page 28, annexure H 77, page 73. This was, Millard, in the year 2022, August 13th, I led evidence in MC, and she has not cross-examination taken as nil after long process. After 1 year, in the year October 2023, this order is passed. All of a sudden, the family court did not posted the matter for respondent evidence after taking the nil of the cross-examination without posting of the respondent evidence. With the court itself has taken this application voluntarily and disposed of this matter. What was the purpose? And it is very ambiguity, Millard. So this was, and in this it is admitted under these page 77, Millard, and therefore the income of the party is uncertain under these circumstances when the relationship is not in dispute and the children are residing with the father. It is admitted fact that I am the looking after the father, the children. The petitioner, being the husband, is duty bound to maintain his wife, and it is the moral obligation to the same. It is not, none of the Supreme Court judgments are said, not on this particular facts of the cases should obligation and to the pay the, not even one judgment is not there, not like this kind of one. However, the petitioner who has claimed the divorce on the ground of adultery, and until and adultery is proved in accordance with law. Even assuming, I have already led evidence, this honorable court is direct the family court within 3 months, let them evidence, cross-examination, and
yes,
it will be. I'm because my part of the job is already over.
What do you say?
Lordship, settlement is secondary, but my question is this one. Family court has aptly passed the order because there is a standing position or decision of the Honorable Supreme Court unless it is established. His wife is entitled for maintenance. It is a mere allegation. My client has filed counterclaim, Your Honor. Whatever document he has produced, along with my client has filed counterclaim, restitution, RCR. She has sought RCR. In spite of it, merely because she has not cross-examined, case is not closed. Case application we already filed. Application is allowed. I have to cross-examine the PW1. The court cannot take it granted as she is already having adultery. It cannot be said unless it is decided. And moreover, his client is owning his own car. He is the driver of the car. And moreover, he enriched by using the wife. Second respondent is his close friend. He was no money to construct the house. It is the out of the earning of my wife, he has constructed the house. 8 houses has been leased. There is an official privileged communication with me. Your Lordship gives an opportunity, definitely I will play the whatever she has said. This is the problem. After 2 years, after lapse of 2 years, single pay has not been paid. How she can survive? She is exposed to the society. Society is teasing her. You have left the husband. You have left the in-law's house. In-law has used your money and...
It's not going to all those emotional aspects. Please make submissions on the legal aspects. That's what I want to know.
Yes, Lordship. The order passed by the family court is aptly right.
Yes, please come. Agreed with the orders passed.
One more submission. In that 18/3/2022, I led evidence. Thereafter, my lord, it was taken as nil, respondent absent, and taken as nil of the respondent.
How does it have a bearing on the maintenance case?
And thereafter, in 23, filed an application for recalling. It was not heard. It was taken as, and all of a sudden, it has jumped into the conclusion that this application was not. And also, one more, my lord, submissions. This order passed by my Leonard Fund only when we was when he was judge.
No, I am a retired district judge. I am not prevented by.
I'm not telling.
Representing
I'm sorry.
I will tell after 1.5 years.
Of this honorable court. Why kindly see the order sheet? Why it has taken up this supplication is in between without posted for respondent evidence. He has taken the application and passed an order. What was the,
What is wrong
what
in
was
it?
the,
I am
kindly
a
see,
judicial
I'll
officer of
place
the
the
court.
order
I have
sheet, my lord.
passed
It is
order.
a certificate
You
copy of
cannot
this.
blame me.
No, I'm not, I'm
Yes.
sorry. I'm not at
Yes.
all blaming, I'm sorry. It is brought to the notice of this
I
honorable
am not
court. This
deprived
was
of
happened.
practicing before.
This
High
was
Court.
happened. I'm sorry, my lord. I'm not, Netherlands friend is practicing now. I'm not at all, this is
I am,
going on in this
I am
matter.
pressing equity, Your Lordship.
From the
I am
beginning,
entitled to
A to
practice.
Z, he knows very
Client has
well
approached
this
me.
case is concerned.
Client has
GNWC and as well as same court, my lord, both the matters was pending before the court. My lord,
Fortunately,
I'm
we
sorry.
are going somewhere which is unrelated to the case, unrelated to any of it.
Sorry, this is the, I'm
They have
brought
to-
to the notice of this
parties
honorable
are-
court. This was
clients are
on
to-
record. It is the record I'm showing and
How does it make any difference?
not that.
Are you trying to attribute any
So
malpractice?
therefore, my lord, this application is not at all.
Yes, agreed, but the orders
Kindly
passed
allow
in-
the petition, direct the family court within 3 months, dispose of the matter. Kindly quash this
The orders
impugned
passed in
order.
I
That
number
is my
5.
submissions.
In MC number 1657 of 2020.
Request Lordship to give means to
30th
the, our
October
client and
2023,
let them
where-
pass whatever.
What is it?
The means is should be awarded to my client. Then the rest is whatever in the next negotiation. Actually, Your Honor, in submission, they were trying to avoid me. They are trying to avoid me. They have threatened my client. There was a conversation.
I think I'm not, I'll not pass orders then.
Yes.
You're pushing the court to that
Yes,
extent.
Your Lordship. Yes, pass Your Lordship.
Agreed with orders passed in I number 5. If this kind of every day, all the advocates start arguing like this, court can't even hear 2 matters a day.
Yes, yes, Lordship. Sorry.
Agreed with orders passed in I number 5 in MC number 1657 of 2020, dated 30th October 2023, whereby the court had granted maintenance of an amount of rupees 15,000 to the wife. The husband is before this court. The wife had filed an application for interim maintenance of an amount of 30,000 for maintaining herself and two children, and litigation expenses of an amount of rupees 1 lakh. According to her, the husband is having his own cars and his income is 1,20,000. The husband has filed his application, filed his objection stating that wife is living in adultery and he is taking care of the children and she is not entitled for maintenance. The court by order impugned and granted 15,000 maintenance. The court observed that both the parties have not stated the wife had not stated her income and her assets and liabilities, but she has stated that the husband is getting an amount of rupees 80,000 per month, who is owning cars and is liable to pay maintenance. According to the husband, the wife is getting income of an amount of rupees 50,000 per month from working in the garment factory. The court has observed that both the applicant, both the wife and the husband have not produced any supporting document. What supporting documents to show what is their income. Considering the fact that the relationship of the parties is not disputed, and with regard to the allegations, with regard to adultery and other things that have to be decided during the while deciding the petition, and considering the fact that children are with the husband, court had granted an amount of rupees 15,000 from the date of application and litigation expenses of 5,000. Land counsel appearing for the petitioner husband submits that the wife is not entitled for maintenance as she is living in adultery. Court has granted the custody also to the father. It is submitted that the normal case where maintenance is granted to the wife, that is not available to this petitioner, to the respondent wife, as she is living in adultery. She is not taking care of the take care of the children. The court, without any basis, had granted maintenance of an amount of rupees 15,000. It is submitted that even in the MC case also, the wife is not cooperating, and there shall be a direction to the court to expeditiously decide the matter. This is pending before which court?
First additional.
First additional family court, Bangalore.
See of which year?
2020, Your Honor.
It is, what did you write? Decide the MC pending before the court. Next one. Then counsel appearing for the respondent submits the order in the GNWC is an ex parte order. She has already filed a miscellaneous application, and the same is pending consideration. Mere allegation of adultery will not prove the same unless and until it is held by the court that the wife is living in adultery on that ground. In a summary proceedings under 125, in an IA that cannot be decided by the court. It is submitted that the court had rightly considered and granted maintenance, and there are no grounds to interfere. Next one. Having heard the counsels on either side, there is a material on record. The whole contention of the learned counsel, it's a whole contention that is put forth on behalf of the husband is wife is living in adultery, as rightly argued by the learned counsel for the respondent. When the main MC itself is filed, seeking divorce on the ground of adultery, unless and until the same is proved, the court cannot consider that or cannot come to any conclusion that the wife is living in adultery. Then coming to the financial capacity of the parties, both the parties have not filed a statement of assets and liability as envisaged with the Honorable Apex Court in Rajneesh versus Neha. Then the court, basing on a guesswork, has granted an amount of rupees 15,000. Nothing has precluded neither the husband nor the wife to place a statement of assets and liabilities. Then coming to the fact that this is a MC of 2020 and the same is pending already for the first additional family court, there is a direction to dispose of the MCs of 2020 by December 15. Hence, in the light of the above discussion, this court is passing the following order. No, before that, as the court had given an amount of rupees 15,000 basing on a guesswork, and that to the fact that both the children are residing, and there is nothing on record what is the income of the parties. This court is inclined to modify the order accordingly. The following: the MC number, the order passed in so and so is modified, and the amount of maintenance is reduced from 15,000 to 10,000. Next, the MCs of the year 2020, the principal judge family court shall dispose of the same by December 15. Unnecessary adjournment shall not be granted. Next.
Cell number 2, Rajaram is for petition appellant, PC Sitaram Rao for respondent.
Yes. Who is R3 and R5?
My Lord, I filed dispensation for dispensation memo for 3 to 5, my Lord.
A memo is filed seeking dispensation of notice to R3 to R5. The same is taken on record and notice is dispensed with. What is this IA 1025?
Remit back the TCR, my Lord. Because in trial code, the respondent deposited the amount, my Lord. The claimant is a bedridden. Kindly remit back the
IA number
order sheet, my
125
Lord.
is filed to return the TCR for withdrawal of the amount. Learned counsel for the no representation for the respondent. Considering the submission, I number 1 of 25 is ordered, and the registry is directed to return the TCR for the purpose of withdrawal of the amount. Next, IA number 1 of 22 is filed to condone the delay of 24 days. For the reason stated, delay is condoned. Admit post for final hearing. Once the amount is withdrawn, the TCR shall be sent back to the High Court. Yes.
Serial number 3. Serial number 3.
Appealing for respondent number 2, my lords.
Memo for acceptance.
Memo is filed for acceptance of the paper publication by order dated so and so. This court has ordered for paper publication. This peruse paper publication and the same is accepted in the name of and notice in respect of R1 is held sufficient in the name of the party. Admit post for final hearing TCR. Next 4.
Serial number 4.
Obliged.
Jagdish HT, petitioner K. Nagarajaya.
Kindly dispensation of notice to R1.
Notice to?
Respond number 1 to 3 minutes.
Two memos are filed. One is to dispense the notice to R1 and R2 and R3 for the reason stated. No, considering the same, the notice to so and so is dispensed with at the risk of appellant. You appear for the insurance company.
R4. Respond number
No
4.
insurance company.
R4 insurance company. R4.
That's what I asked you. Appear for the insurance company. Yes, admit post for
Kindly
final
refer to
hearing.
Lok Adalat. Refer to Lok Adalat.
The list is matter. Admit post for final hearing. By admit call for the TCR. It is submitted that there is a likelihood of settlement. List is matter before the Lok Adalat.
Please.
Yes, next.
Serial number 5.
Appearing for the appellant. One more appeal is pending. Miller.
Another appeal by the party.
Another appeal, Miller, company only. Miller. 4548 of 22. Miller. Tomorrow.
In that, this R5 is served.
R5 no, Miller. It is not served. Owner of the vehicle was placed ex parte. Passenger carrying the goods vehicle challenging the liability. Miller.
You are questioning the liability.
Liability question.
Then it's the notice to him is necessary.
He was placed ex parte, madam. Millard, tomorrow, Millard. Tomorrow, both the cases I will file.
I'll list along with so and so tomorrow. Give that, write it on a paper and.
Please.
Yes.
Serial number
Yes.
number 6. Satish Chandra.
What is this, for the first time?
My lord, it's the 343 is filed by the father of a deceased, and another connected matter is preferred by BMTC. BMTC, I guess.
No, in this matter, who is the?
I tried
1
to
minute.
I sought a permission to serve a copies on the.
No. What about 1, 2?
Dabali.
No, 1, 2, Dabali will not appear.
Respond number 4 not.
Yes,
4 is appearing.
Will appear.
Yes.
What about notice to 1, 2, 3, 5?
I, with the permission of the court, I served on the advocate appearing for a connected matter, my lord.
Where is that advocate?
Advocate has not, but.
I appear for the respondent number 5.
5. Only 5.
5.
Not.
Very active.
My lords, in a connected matter, he appeared and filed a wakalat. With the permission of the court, I served on the.
Hey, I'm saying, what is the name of the advocate?
M. Mahesh, my lord.
I appear for the respondent number 5.
Where is he? He has accepted notice?
Please, my lord.
Bring the name of Mr. Mahesha M.
Please.
Appearing for respondents.
1 to 3, my lord.
1, 2?
3.
1, 2, 3.
In my appeal.
Yes, 1 to 3. 4.
4 is Dabali, sir.
Mr. Dabali is directed to take notice.
5 is Sangamesh.
And 5?
Sangamesh is appeal.
5, Mr. Sangamesh is directed to take notice as both of them are appearing in the connected appeal. Then counsel for the appellant shall serve the copy of the petition on the counsel. Admit post for final hearing. Call for the TCR.
Obliged.
Just next statement.
Serial number 7. Serial number 7.
What is this letter?
I am for the respondent, Your Lordship. Respondent number 1.
Of the amount.
Your Lordship, since we are awaiting for the medical reports, so I kindly request for a 2 weeks of time, Your Lordship.
That's a letter, I think. Yes. At the request of the counsel, the respondent list is matter after 2 weeks. Yes, next.
Much obliged, Lordship.
Serial number 8.
I pay for appellant counsel in this case.
Not deposited the amount?
No, I deposited already. It's a short time for the filing the deposit number.
Shall I record that it is,
It
counsel for the appellant submits that the amount is already deposited. You will place details on record. Next, I number 1 of 23 is filed to condone the delay of 12 days, admit post for final hearing. Call for the TCR.
Serial number 9 for admission matters. Serial number 9, Umesh K.
For the appellant, my lord. Memo along with the depositing receipt filed on 25/7 in office, my lord.
Already deposited. It is submitted that the amount is deposited and the receipt is also filed before the registry. All are served.
Yes, my lord.
Yes.
Admit post for final hearing. Call for the TCR.
TCR is.
Yes.
Serial number 10. Serial number 10.
Admit post for final hearing. TCR.
Serial number 11.
I am for the respondent, my lord. Cognitive disability is assessed as lower than what the expert has opined, my lord. As against 35%. LCR is required, my lord.
TCR is admit
Please.
post for final hearing. TCR. That's what I'm about to do. When you're asking, I
Please,
didn't want to
that's-
argue. That's why I'm asking.
I just request, my lord, for date me fix, my lord.
Admit post for final hearing. Let the TCR come.
Please,
Then you
ma'am.
will take up all 23
Please.
matters once they come. Yes.
Serial number 12. Final hearing matters. Serial number 12. Rangegowda NR
Who appears for the respondent?
for appellant.
I appear for the respondent in the second case, my lord, appellant in the second
No.
case.
You're for the insurance company.
Yes, my lord. My lord,
Where
in
is the
this-
claimant advocate?
Rangegowda NR.
My lord, in this case, I have taken RPAD, some notice through RPAD that has been, when it has been returned with an endorsement dated 9/9/2023, stating that the party has been dead. Party has died, my lord.
Who died?
Responding, owner of the vehicle. That's why I have filed an application to bring his LRs on record, my lord. The office has raised an objection stating that the date of death or certificate of the death certificate has to be provided. That has to be overlooked, my lord, because we have made an effort. We could not get the document.
Will issue notice to them and see.
Please.
It is submitted that the owner of the vehicle is no more. An application is filed. Then how do you know the details of the LRs?
This honorable court has issued RPAD details. Okay, by with an endorsement by the RPAD cover, we came to know that the party is dead on 9/9/2023.
Then no, how did you know about the LRs?
LRs, we have collected the information through our agent, my lord, investigator.
You can also get the other
Because
details.
she is old age lady. That is the reason she could not even remember what is the date of death and all, and she has not obtained any death certificate.
Already appeal is dismissed against RP.
He has placed ex parte, my lord.
This court, a coordinate bench of the court has already passed an
Your
order.
lordship is correct.
So what remains now? Why you want,
I
when
have
it's
filed
already
I
abated,
have
why-
filed 3 applications, my lord. to
after
satisfy-
that order, before that order?
After that order.
To satisfy the abatement also?
Please, ma'am.
Then counsel for the petitioner submits, appellant submits that the owner of the vehicle is no more. That they came to know when the notice is sent from the court. As for the postal shara, that he died. Thereafter, they could get the details of the LRs. But with regard to the date of death and all, in spite of their best efforts, they could not get the details. In these circumstances, this court deems it appropriate to direct the registry to issue notice to the, which IA is that?
That is one of it. 1, 2, and 3 of
1, 2, and 3, ma'am.
25.
A notice
The
to
connected-
IA number 1, 2, and 3, so that once the notice is issued and they come on record, the insurance company will be able to get the details. Yes.
Serial
This
number
is matter
13.
after service of notice.
Serial number 13. 13, Puttaswamy C.
I pay for the appellant claimant in MFA number 1240.
My lord.
I will, once let me look at it, when he's making a complaint, like every time this is happening. Twenty-three seven. Sri Puttaswamy and counsel appearing for the appellant is present. Sri B.S. Umesh and counsel the appellant in MFA, who is appearing for respondent number 3 in the connected matter, appears through video conference as he is unwell and he seeks a short accommodation. 27. Sri B. Umesh and counsel appearing in the so-and-so and seeks time. Respondent number 2 called absent.
From last 2 years, he's taking this adjournment. Only for the ground that the driver of the offending vehicle had a learner's license. It is covered by the division bench of this court. The same was relayed by the trial court.
What about in the, how many, one matter, two matters? It is represented that land counsel for the respondent is out of, he has some personal inconvenience. Land counsel for the petitioner submits that on every occasion from the last 2 years.
Yes, my lord.
From the last 2 years, the counsel for the respondent is continuous. Matter is not argued. The matter will be heard and appropriate orders will be passed, and the cost will be imposed on the insurance company for dragging on the matter. Yes.
Much obliged.
Cell number 14, Pradeep B for petition appellant. Madhusudan MN.
Amount deposited or not?
Appearing for the appellant, my lord, respondent.
Deposited?
Please, my lord.
It's a 20.
8,44,976.
8 lakh 40?
44,976.
Land counsel for the insurance company submits that they have deposited an amount of rupees 8,44,976. You're on what point?
Challenging the liability, my lordship.
Liability.
Liability.
We'll hear it.
My lord, insurance copy and other documents are not there.
Not now. I'm saying like there is no permission to withdraw. You have not filed any IA.
No.
It is submitted that already the amount is deposited. Admit post for final hearing.
It's finally.
Cell number 15,
15.
is in hearing only. Is hearing.
Finally.
Already, I think this is adjourned.
Yes.
Sought for time in this also.
Lord,
This is adjourned from how long?
almost a year, my lord.
Same this also. This also same like in the other matter. Like that is 2 years. This is 1 year. Same like it will be heard. Orders will be passed and costs will be imposed on the insurance company.
Pleasure,
Yes,
my
next.
Number 16. Cell number 16.
But claimant appeal for enhancement. And in this case,
In
insurance
this
company
case,
also.
how many years?
My lord,
In this case, adjournments for how many years?
no, my lord, I am ready.
Not you. I'm saying they're already ready for adjournment.
My lord, 2 days back, matter is posted, my lord. This honorable court today is posting the.
Give the order sheet.
Last time matter is not reached, my lord.
This list this matter along with those 2 matters on the same day. When is it posted? Tuesday. On that day, this matter also. At the request of land counsel respondent, no other order, just adjourn it. Yes.
Cell number 17, Ashok N. Patil for appellant. Chandrasekhar Swamy KB.
Insurer.
For
appeal.
respondent number 1 to 4, my lord.
You're on what ground before the court?
Minutes, insurer appeal minutes on the ground of that the deceased also minutes contributed for the occurrence of the accident because minutes.
Anything to be considered or
Yes,
not to
minutes,
be
yes,
considered?
please. Minutes.
Please
Because
come
minutes-
to that paragraph of the order.
He was the minutes a pedestrian. Minutes, he was crossing
What
the,
time is the accident?
the accident is at minutes 6:40 PM.
6:40 PM.
6:40 PM.
Where
yes.
did the accident happen?
Minutes, it is on a minutes Kempegowda bus stop near Sai Baba Temple, Ring Road, Bangalore city. Minutes.
Near the bus stop.
Near the bus stop. Yes. Minutes. Kindly see minutes. See the.
Come to that, that particular finding and that
Yes,
particular
yes.
paragraph number.
9, my lord.
Paragraph number 9.
Please read.
The general rule is that a vehicle should be driven at a speed which enables the driver to stop within the limits of his own vision, and failure to do this will almost always result in the driver being held responsible for the collision. In other words, it is the duty of the driver of a vehicle to keep a good lookout. In this regard, perusal of exhibit P5 spot sketch indicates that the deceased has already crossed 90% of the road.
So
and
the
was-
accident has not happened in the middle of the road.
It is, my lords. Because, my lords, it is a 2-lane, my lords, he has crossed the center median. He was supposed to cross the center median. Your Lordship, therefore, my lord, kindly see the sketch, my lord, for a moment. Lordship will my lord, get my lord, where the accident has taken place.
It's a case of death or injury.
A case of death. My lord.
Exhibits as sketch.
His here is there.
Yes, ma'am.
Show.
Exhibit P5 minutes, I think, is the sketch.
Yes, fine.
Spot sketch.
Let's see.
Minutes, the road is about 40 feet, my lord's width. Minutes, he's minutes, crossing from the minutes,
From E to A.
E
to
to A
B.
minutes is crossing. He
Huh.
wants to cross minutes across the road. This is the minute, A is the minutes, the spot of accident.
You are coming from where?
But she is coming from this bus stop. Please, I am coming from minutes. The,
F to A.
F to A. Yes, minutes.
Then how can you
Yes.
say that it is middle of the road?
But he is not trying to cross across the road, minutes, E to A, but he is to cross not the other lane also, 40 feet plus 40
No,
feet.
whatever it
He has
is,
to
but the
minutes
accident
cross the
has not.
central median lane.
Accident has not happened on the other end of the road. That happened this end. So he is already almost, unless and until you are in the extreme right side, if you are not going with that speed, the accident would have not happened. The finding is correct.
Kindly see, minutes, it is not at the edge of the left side of the road, minutes, it is near the center median of the road.
Only a little bit. It is almost the end of the road, end of that road.
There is
about
no
to reach
zebra
the-
crossing, minutes, that is what, minutes, is the point, minutes, which I want to draw your Lordship's attention. That, minutes, there is no zebra crossing here.
Before the bus stop.
Yes, minutes, it is, minutes, it is near the bus stop, but
What is the speed you are maintaining at that place where you are
if
supposed
it is a
to?
bus stop, minutes, I would also be, minutes, traveling in a very, minutes, moderate speed. If he has not suddenly crossed, that, minutes, the kindly see, minutes, I'll read, minutes, their admission also. From the, minutes,
For the eyewitnesses to this.
there are no eyewitnesses, minutes, only,
Then
minutes.
whose story? What story they
Your
will
Lordship
tell?
may kindly see, minutes, what they have stated in their evidence. I submit that on 28/9/2018, it is the evidence of PW1. At about 6:40 PM, my husband Tippanna Tippesh Chandru was crossing the road from Kempegoda Arch bus stop to Vishal Mart near Sai Baba temple at that time, so and so minutes. It is their own admission that he was trying to cross, minutes.
That is, for that no admission is required. It is an admitted
It is a
case
document,
that
yes, ma'am.
It's crossing the road and it is.
There is no zebra crossing, minutes, at that point, at that place where the accident has taken place.
I'll
Therefore,
record
minutes,
the
certain degree of, minutes, negligence, minutes, because it is not, minutes, only, minutes, because of my negligence, the accident has, he has tried to suddenly, the second point is that, other grounds are those. May I point out. Not the disease.
Anything on quantum?
Yes.
What is, which year is this accident?
The accident is in 2018.
What is the amount taken?
The tribunal has taken.
Income at how much?
12,500.
12,000.
Personal income.
Yes, ma'am.
10,000?
12,500.
Which 12,000?
2018 minutes it is there.
Correct.
Yes, ma'am. No, minutes. My
What is the age?
other contention is this, minutes.
35 years. Exhibit P8.
So 40% future prospects are also taken.
Taken.
May 7.
Prisoner.
One more ground is that, minutes, he had two wives. The deceased had, minutes, two wives. It is not proved that, minutes, by way of document that he had married both of them. Minutes. Both of them are petitioners here.
So
1/3 should have been deducted as against 1/4 is my second, minutes, contention. Third contention is that, minutes, the age of the,
so
minutes,
both of them were considered as his dependents.
it is, minutes, it is, in fact, it is indeed
How can
considered.
it be?
My lord, it is the first wife who has given evidence. And she has not begotten any children. Therefore, she herself.
Something which is not legally acceptable. How can that be considered? How can there be two?
My lord, even if.
So even otherwise, in
Even
case of a married
yes.
man, this court is not deducting 50%.
No, minutes, I am not asking for 1/3, minutes. There, now the tribunal has deducted 1/4. 1/3.
How many are there total?
Total, the 4 minutes, including the second wife.
If it is not there, it will be 3.
1/3, it will be 1/3.
That we will consider.
Children are there. Children. The first wife herself has led the evidence.
Whatever it is.
She is second wife. She is also dependent of the deceased, my lord.
How do you, how can we accept something which is not
Please, my
legally
lord, in the
permissible?
recent judgment of the apex court, my
What
lord,
it says?
my lord, in the similar circumstances of the case, my lord, if the any third person who are in a living relationship and they are, if the husband dies, though she is not married, she is on the dependent of the deceased.
That is a different aspect.
Likewise, my lord, here she is the second wife. The respondent number
judgment?
2 and 3 are the
Where is
children.
the judgment? Where is the judgment? Please.
I will produce.
Yes.
Even otherwise, my lord, there are two children, my lord. Even if they are considered legitimate or illegitimate, they are entitled. Two children are there and one wife is considered.
That's what, that only will consider, but he wants to
Please, my
consider
lord,
the
I will
other
produce.
wife.
Please, ma'am.
Yes, at the request of learned counsel for the respondent, list the matter on next Thursday. What's the date?
17.
Yes.
Cell number 18 adjourned. Cell number 19.
From now onwards, no family matters on the Thursday. Whenever giving the date, you remind me. Yes.
I prefer respond.
19.
For the appellate. Case of injuries.
Yes.
This is in respect of MEC 3630 of 17. The relevant.
Please come to the table. Table.
Table.
And what, how many fractures?
Para 16 of the judgment. He suffered a distal V3rd femur right thigh with a type 3 compound fracture tibia.
There are the numbers to the paragraphs. Yes.
Para 16 page number, internal page 30.
There are two MBCs. Which MBC?
This is in respect of 3630 of 17.
3630, yes.
Got it. Page 13.
16, yes. 3630.
Yes.
How many are the fractures?
V3.
Petitioner suffered compound fracture of distal end of, so one fracture.
No, not one fracture. In the internal page 13, diagnosis is distal V3rd femur right thigh with type 3 compound fracture tibia, post-traumatic raw area right leg with exposed tendon. He underwent a supercondylar nailing with external fixation right leg on 9/2/17, skin grafting with flag cover post-traumatic raw area right leg. So, on the second occasion, he was in the hospital, general hospital for
Before
30
going
days.
into that, I'm asking about the injury. Injury is one.
Yes.
If I underwent surgeries, but injury is one.
Injury is
One injury as per the.
But for 51 days, he was in the hospital. And the first occasion for about 21 days, and on the second occasion, 30 days.
What do you say on pain and suffering?
Pain and suffering.
Pain and suffering.
Court has granted 50,000.
50,000.
I think it's reasonable, I think. As far as pain and suffering is concerned.
No, generally, whenever it is, no, because he's that many days in the hospital, we'll grant it on the other hand. How we are calculating is, basing on one injury, it is one fracture, it is 40,000.
But it is not one injury.
That's why court has already granted
He has
50,000.
got traumatic raw area on the right leg.
That's why court has granted another 10. 50 is granted. We'll see on the other heads.
Attendance has to be increased.
That we will do.
It has to be increased because 51 days is there.
Yes, medical expenses.
As it is.
1 lakh.
Later period.
1 minute. 1 lakh 54,000. Then attendant. How many days you say?
51 days.
That is also reasonably granted. So we'll increase 1 more thousand, 51 days. So 51,000. Then loss of income. What income is considered?
12,000 rupees. Court
12,000 rupees.
Which year is this?
Skilled worker, fabrication work. He was doing fabrication work. And in fact, the salary produced itself is 13,100. Court has taken 12,000 rupees.
As per salary certificate, it has been taken.
No, it says 13,000 is saying.
13,000.
It is mentioned, it is discussed.
Employer also has been examined. He has been removed from the service.
So how many months it is given?
3 months.
3 months.
So even if we consider that another 3,000 will increase. So
Yeah, for 51 days itself, he was in the hospital. At least
51
6
is,
months.
that is 2 months.
Yes.
Another 2 months.
At least 6 months.
Well, as far as salary is concerned, it has been discussed at para
51 days
15.
means he has
Para
to.
He was in
15.
hospital for 2 months.
Yes.
51 days.
At least another 3 months he has to be under bed rest.
Then it comes to 65,000.
Yes. And so far as loss of future earning capacity is concerned,
What is the permanent disability?
the doctor PWFI says 63.23%
To the
limb and 31.6% to the whole body.
correctly taken.
Correctly, but
No,
court
it is- it
court
should be
has
this
taken only
one
Less
third.
than that, 60 to 1/3 it should be.
12% is taken.
21 is correct.
but court has taken 15%.
21 is, we'll take 21.
Yes.
1/3 is 21.
And
So, 13,000 into 12 into what is the multiplier? 30, what is the multiplier?
12,783 is he was earning. It has been discussed in the
12,000?
783.
But
As
you-
per Exhibit P17.
How you are saying it is 13,000?
As per Exhibit P17, pay slip.
that is inclusive of other benefits, 13,100. Employer says 12,783.
Then we will have to take that only.
Oh, yes.
12,000?
783.
Say 12,800 maybe taken.
No, yes, we'll round it off to 12,800.
Yes. And since more than 20% future prospects has to be considered.
Into 6. 70. It comes to 64,000. So this 12,800, what is the multiplier?
13, but future prospects is 10%.
What do you say?
I don't think that in
Above-
this
above
case,
20.
in
Yes,
this
we-
case, it's warranted.
He has been removed from the
12,800 into 12 into, what is the multiplier?
13.
13.
Into 21 by 100. It comes to 4,19,318. 328. Loss of amenities.
Amenities, another 20,000 could be there.
Another?
20,000.
More than that. He has to suffer, and there is the doctor says the right femur shows malunion and non-union.
60,000 will give. Yes, another 30,000. 10,000 legal expenses. So,
Future medical expenses, 30,000 is granted.
the same.
He has to undergo 2 surgeries.
What is the evidence that how much it will cost?
Court, doctor says 60,000.
If it is 2 surgeries, then generally one surgery we are
I
granting
leave it to your lordship,
30,000. Huh?
because I don't. I leave it to your lordship.
Because one surgery we are always granting 30,000. It's coming to 8,69,106. Please come. Agreed with award passed in MVC number 3630 of 2017, dated 2nd April 2019, whereby the court had, the tribunal had granted compensation of an amount of rupees 5,75,418. The claimant is before this court. Then counsel appearing for the claimant submits that the claimant had sustained a compound fracture of distal end of the right tibia, post-traumatic raw area right leg with exposed tendon. He also underwent supracondylar nailing with external fixation right leg on 9/2/2017. Skin grafting with flag covers post-traumatic raw area right leg. And he was in hospital for 51 days. But still the court had granted an amount of rupees 50,000 towards pain and suffering. And when it comes to loss of earning during the later period, when the employer has stated that the income is 12,800,
783,
12,000.
783? 783, court had taken 12,000. It is submitted that as per when the doctor has given evidence that the future, for the future operation, it will cost 60,000, but the court had granted only 30,000. It is submitted that considering the kind of injuries and as the same is not united, the court had granted for the law of amenities only an amount of rupees 30,000, which is on the lower side. It is submitted that as per the evidence of the doctor, the disability to the whole body is 63%. Then on 1/3 of it, the limb disability would be 21%, but the court had taken 15%.
15%, 15.
It is on the lower side. It is submitted that the order impugned. It is submitted that the court below had failed to consider the evidence in its proper perspective and also failed to grant a just and reasonable compensation. Next para, when counsel appearing for the insurance company submits that court has considered all the aspects and basing on the evidence had rightly granted the compensation. There are no grounds to interfere. Next. Having heard the counsels on either side, there is submitted, not recorded. The court, there is one fracture and he had undergone the.
Two fractures.
It's only one.
Femur fracture and fracture of tibia. Two fractures.
Yes.
Two fractures.
It has been referred to as only one fracture. That is compound fracture of distal and right tibia.
Correct.
In the judgment.
It's a compound fracture of.
That is
That's why another 5,000, 10,000 is already added.
Of distal end of right
fracture
tibia.
of distal and tibia, court had granted 50,000 and this court finds no reason to interfere. Coming to the medical expenses, basing on evidence, court had granted and no interference is called for. Coming to the attendance, food and conveyance, for 51 days of hospitalization, this court is granting 51,000. Coming to the loss of income during the later period, court had taken the income at 12,000. According to exhibit P17, the income is 12,783.
Yes.
83, but the court had taken 12,000, rounding it off to 12,800. This court has taken the income at 12,800. Coming to the disability, when the whole body disability is 63%, when the limb disability is 63%, the whole body disability should be 1/3 of it. It comes to 21%. 12,800 into 12 into the multiplier 13 into 21 by 100 is 4,19,328. Coming to the loss of immunities, considering the evidence of the doctor, the injuries, the fracture, and as it is small united, this court is granting 60,000. Coming to the future medical expenses, the doctor has said that he has to undergo 2 operations. For one operation, the court is granting 30,000. Hence, as it is 2 operations and the court is granting 60,000. In the light of the law laid down in Mekala vs. So-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 8,69,106. the enhanced amount, you take there will be an order covering all this. What should be the enhanced amount shall carry 6%.
Cell number 20. Puttur Padmavati Suresh.
I appear for the
Well,
defendant in this case.
appearing for respondent, copy is not served yet.
What is this? Is it a case
It's only
of-
on quantum matters.
You can, you can just watch what's happening. Court will look into your interest.
I'm for the claimant.
Huh?
I'm for the claimant.
You're
Yes.
for whom he is?
I think he's for the
Respondent number 2, my lord.
owner.
To owner of the vehicle, yes.
It's only on quantum.
Liability.
Liability is
There's
admitted,
nothing for him. Yes. Where is the table? Come to the table.
Minutes, table is not there, minutes. Global sum of rupees 4 lakhs is awarded.
How can it be?
Minutes, that is why minutes we have questioned it.
No, global sum, it is some kind of 30,000, 40,000, just like that.
Yes.
4 lakhs can't be global. So we will calculate.
I'll on submission. I agree with there is some discrepancy in not examining with the overall appreciation of evidence on record. This is a fracture of left ankle bemolar.
No, what I'm saying is, whatever the evidence that is there, basing on that, we'll make the calculation. If you do not make, how can there be 4 lakhs
No.
globally?
Therefore, my lord, I'm making submission. The fracture of bemolar. Doctor has given a certificate to the extent of 32.08% of the whole body. It comes to 10 to 11% of the
I mean, limb disability.
the whole body, whole
Mm.
body, 10% of the whole body. But if that is taken into consideration, the assessment is perfectly all right. But if permanent disability is, entire permanent disability is taken off only because the doctor is examined, will you
It's
put
not
in?
examined.
Doctor is not, admitted, doctor is not
Is it
examined.
your point?
Yes, ma'am, that is my,
We'll remand this matter.
yes.
Remand the matter.
It's my only submission because minutes, if they had minutes, that opportunity they had already. Its interest may be denied for this period because minutes, they are now seeking remand.
No, why?
Because my lords,
Lord, these
I have deposited minutes, my admitted amount 2 lakhs which they have withdrawn. For the minutes enhanced amount, no interest because minutes, it is for their minutes mistake. Minutes, my only submission minutes.
So in all the remanded matters, interest
No
should not
minutes
be granted.
here, it could have been done minutes in.
Leave it, or on these kind of grounds only remands will be made in all the cases. What is the exception to this
poor
case?
agriculture is nearly 250
Please come.
kilometers away.
Agreed with orders passed in MVC number 146 of 2019, dated 30th
May I
July.
submit this minutes? If your lordship is minutes taking some disability minutes, say minutes 50,000 rupees, a global sum, minutes, this would minutes end this.
Minutes for this.
Then nothing will come.
Nothing.
That amount, he will not be near to that, somewhere it will end up at 1.5 or so. If you take that way.
Strictly speaking, there is no injustice, but I have not examined the doctor, my lord, he is an upper and I cannot do anything.
Agreed with the orders passed in MVC number 146 of 2019, dated 30th July 2022, whereby the court had granted global compensation. I think I've never seen a case like this. 4 lakhs global compensation.
4 lakhs is the word, yes.
Has granted global compensation of 4 lakhs with interest of 6% per annum from the date of the petition till its realization. The claim petition is filed seeking compensation of an amount of rupees 9,45,000. The claimant had sustained, according as per the certificate issued by the doctor, he had sustained 35% disability to the
No,
leg.
minutes, 32.02 minutes as per the disability certificate.
32.02% disability to the whole body, to the limb. And the doctor was not examined. The insurance company is precisely on the ground before this court stating that without examining the doctor, assessing the disability, considering the disability, giving a global compensation.
On the basis of a disability certificate.
On the basis of a disability certificate, and also on all other, without considering on all the heads, what is the entitlement of the claimant. It is arbitrary, and there cannot be any compensation of 4 lakhs globally. Next, Land Counsel appearing for the respondent submits that there is no dispute that he has sustained the injuries and the fractures as stated, and the doctor has also given the certificate. The only lapses on the part of the claimant is that he has not examined the doctor. It is submitted that is a poor villager, and if any interference by this court would have an impact on it's a case of injury.
Injury.
Left ankle bemolar.
On the claimant. Next part. this court is, having heard the counsels on either side, there is a material on record. The order of the court granting, the order of the tribunal granting 4 lakhs globally, that has to be interfered by this court because that is without any basis. Then coming to the aspect that that he has sustained disability and the certificate is given, doctor is not examined. As rightly argued by the learned counsel for the insurance company, without examining the doctor, that disability cannot be considered. And if on that ground, if that appeal is, if this appeal is allowed, it would cause a lot of hardship to the claimant. Balancing the interest of both the parties, this court deems it appropriate to remand this matter only for the limited purpose of, examining the doctor and basing on the material, assessing the tribunal shall compute the maintenance on each head.
But without being influenced by the observations of this court.
What observation I have did?
No, suppose the entire evidence
I said, without giving under separate heads, giving a global compensation is bad. I said only global compensation is bad because it has to be what is paid, because there are heads for compensation.
For that also I have given evidence, except this.
That's what I'm not expressed to. Doing that is bad.
Please.
Yes, and the parties without further notice shall appear before the court when?
September 1st week.
On September 3rd, and within 6 months from there, the court shall dispose of the petition. This is a which year is the accident? Is of the year 2018. 18. It's next. Huh? Both disposed.
Serial number
Then
21.
you write the insurance company is before this court, and the claimant has filed in the starting. Claimant has filed the MFA crop number so and so, seeking enhancement of harm. Yes, next.
Serial number 21.
Objection is there. I'm sorry.
Girish V.
That also.
Girish V. Baldara.
For the appellant in connected matter,
What
660
is on what ground you are before the court?
challenging the liability of
On the ground?
policy. Liability only policy has been issued by the company. Risk of pillion rider is not covered by the policy.
What is that? I didn't get
Risk of
it.
pillion rider.
Pillion rider is
Pillion
not
rider,
covered. He's a
not-
pillion rider.
As a pillion.
Then what is the law on that?
My lord, as per the judgment of the apex court in the Sudhakaran case and Tilak Singh case, my lord, the risk of pillion rider is not covered, my lord, where there is no additional premium was collected.
Then latest, after the some judgments of the Supreme Court,
Supreme
I mean,
Court still
basing
is-
on the Delhi High Court judgment.
Still it is pending.
No, basing on the Delhi High Court judgment with regard to this pillion rider is decided, like you can't say that because insurance is not paid, pillion rider is not covered. Some judgment is there.
No, madam. In this regard, my lord, that is the only judgment.
There is a provision
Three
for
judges bench of the apex
there is a
court.
provision for a pillion rider. That insurance should cover, you should take premium along with that.
If it is a package policy, my lord, there is no issue on that.
But that is, there is a distinction. With that, there is no judgment on
That
that.
also, my lord, they
It is
can collect the additional.
Take
The
that.
caption of the policy, it is mentioned as package policy, my lord.
No, liability only.
First policy.
Certificate of package, liability is schedule only.
Where do you get that?
First. Top of the policy, my lord. It is mentioned
Reliance
as.
General.
It is mentioned-
Huh.
it is mentioned-
Reliance two-wheeler package
Package
policy,
policy.
certificate policy statement.
Liability only.
No.
After that, my lord, package,
Certificate
hyphen.
cum liability policy schedule.
Initially, they are mentioned as a package policy, my lord.
No, that is there is an hyphen. My lord, it is a
Hyphen
package
is there.
policy, my lord.
Huh?
It is if it is a package policy, the own damage, my lord, IDV, insured declare value has to be given to the owner of the vehicle. That is shown as not applicable. We have not collected any premium on that.
That is the case, they have to issue the policy, liability only policy like that. And they have issued the policy.
Liability only it has mentioned.
Caption of
We do
package
hyphen.
policy, they are supposed to pay the, compensate the.
No, that is one aspect. In a package policy, what is the premium collected? In a liability, that policy, what is the premium collected? There is a distinction. Whatever they have given, whether they have collected or not, that you cannot say that because it's a package policy, still they have written it on that. Though I have not paid, it will cover. But how far it is right, taking that?
My lord, in the computation table, my lord, you have
No,
collected.
like,
the
are you sure
premiums.
that there is no judgment of the Delhi High Court with regard to this?
Next week,
to-
my lord, I will also find out and.
I think there is a judgment which says that because two-wheeler, it has a,
But
you
in
know,
the Delhi High Court judgment, my lord, on that, it has been made a reference to the. The circular, my lord,
after
the
that,
Delhi
that's
High Court
what.
has referred to the
No,
IRDA.
basing
my lord.
on that, you have closed so many cases also.
Please, my lord, IRDA, that is package policy is concerned. my lord. Earlier to this, my lord, in package policy also, you are arguing that the risk of failure is not covered.
Covered.
In Delhi High Court, my lord, has directed the IRDA to clarify this. The IRDA has clarified that in package policy, the inmates of the vehicle earlier to.
Acha, in that you are, even in a package policy also, you are
Kith
arguing that
and
they are
kin
not.
also not covered before that. Afterwards, the kith and kin also covered.
Maybe
because of
that's a
package
judgment
policy.
I am.
That is the judgment, my lord. Afterwards, my lord, the three judges bench of the apex court in Balkrishnan case, my lord, that has been clarified. The act only policy, there is no premium collected, the insurance company is not liable.
Find out some judgments, my lord, so kindly after next week.
Are you sure that you can find,
To find out, my lord.
next Thursday?
Please.
7-8. Cell number 22, Sripad V. Shastri,
Yes, Mr. Shastri?
Vaikesh Sheshgiri Rao,
For responding to one melody.
Papers.
Sheshki Rao is not in station, the Lordship is.
This also Thursday is not appeared to be online. Thursday, no representation for Mr. Shastri at the request of respondent.
cell number 23, Adjan 24, cell number 24, Girish B. Baldara,
Yes, Mr. Shankar. Where is
of
Mr.
death.
Shankar?
Deceased age about 26 years.
Where is he?
Shankar Reddy is here only, my lord.
Passover?
Maybe he is in outside.
Yes. You're seeking enhancement?
Enhancement, my lord.
Case of death or injury?
Case of death, my lord.
Where
Deceased
is
age
it?
about 26 years. Observation made in page para 16, my lord.
Para 21, come to para 21. What is the age?
Age is 26 years, my lord.
26 years. Income?
Income taken is 14,500.
Which year is the accident?
Accident is year 2020.
Rightly taken.
My submission is apart from the agriculture. He was working as a contractor's Ganjalagere Milk Cooperative Society and drawing salary of 16,221.
What is the evidence in that regard?
That salary slip is not considered, my lord.
No. Not filing the, apart from filing the salary slip, have you examined the employer?
Examine the employer, PW2, my lord. PW2.
What do you say then?
It is.
When there is an evidence.
It is
before the
observed in
court-
para 16 of the judgment.
Let's read. Please come to 16 and read.
16. The petitioner have got examined the proprietor of the Arkeshwara Enterprises as PW2. He has stated that this is was working under him. He has furnished the documents from 16 to 20, exhibits 16 to 20. The alleged accident is said to have occurred on 14/2/2020. They have furnished the payslip which mentions the minimum wages of 16,221. He died in the month of February 2020. The same cannot be considered. In the month of January 2020, he was paid 12,285. At the same time, he has furnished the document at exhibit P20 to say the minimum wages payable in the year 2019. As such, the income of the petitioner is not established properly. Further, the petitioners have furnished the Milk Cooperative Society's passbook.
What is that he is doing? He's supplying the milk.
Yes, madam.
Supplying the milk. That for that also I produced the document as per exhibit.
No, in that case.
And also one more
Even
mistake.
if you're supplying the milk, no, how is it going to make the difference now? Somebody else will take it forward, in the
He is
family.
Morning session he is working as a as a labor contractor, Ganjanagara Milk Cooperative Society and my lord.
It's a
Society
salary.
is working as an employee. And
No,
apart
this
from
is
that.
the salary.
Yes, the salary is 16,221.
Who is examined in the?
XPW2 is examined, my lord. Proprietor
There
of
are two things.
Arkeshwara Enterprises.
No. You are saying two jobs. For the first job, you examined somebody.
Yes, ma'am.
For the second job, who is examined?
Second job, I have not examined.
Then?
So far as multiplier is concerned, the tribunal has committed a mistake. He was aged about 26 years.
That is
The
accepted,
applicable
ma'am.
multiplier is
There is no issue in that.
17. Applicable multiplier is 17 for the age of 26
Court
years.
had taken?
18. ma'am.
18 take.
18.
That has to be reduced.
So,
But the,
no, that 16,221 is only, they have shown it as minimum wages. But the court says that for the month of January 2020, you are paid 12,285. And the date of death, I mean, accident is in the month of February.
February, my lord.
That's why court has taken in between that 14,500.
14,500 plus 40%.
Reduce the salary slip, my lordship.
No, if you take 14,500 as the court has taken, 40% future prospects are given.
Yes, my lord.
So everything is given. Unnecessarily, if you interfere with this and that multiplier 18 is reduced to 17, ultimately the amount will be reduced.
Now produce the salary pay slip, which is clearly indicate that he is drawing salary of 16,221.
True, but no, that is only, then read next to that. He died in the month of February 2020. The same cannot be considered.
In the month
In
of
the month of January 2020.
January 2020 also is getting 16,221.
No, court records that it is
less than that
12,285.
amount. Less than that.
Actual wages paid. Apart from that, he is doing sericulture, my lordship. For that also, I produced some of the documents to show that his avocation as a.
Why he is not sleeping? How many jobs he will do in a day? You know, if we interfere with this.
Regularly supplying the milk 10 liter per day, as per the card issued by the society.
Please come. Agreed with the award passed in MSA number 889 of 2020, dated 14th April 2022. The claimant is before this court seeking enhancement of the compensation. Land counsel submits that the tribunal.
My contention could be taken note.
And land counsel for the petitioner submits that when he has produced the salary slips, that's exhibit P16 to P20, and when he has examined the employer, show that his minimum income is 16,221, and further the claimant, further the deceased was in a milk cooperative society, working in a milk cooperative society, and he has also produced the passbook for from 1/1/2019 to 2/2/2020, in which he was paid 1,16,914.41 in rupees 1,05,262.96 paise. The court had taken the salary at 14,500. It is submitted that the court ought to have taken the salary, both the salary that he is from Arkeshwara Enterprises as well as per the evidence of the Milk Cooperative Society. Land counsel submits that the court had failed to consider the evidence available on record in its proper perspective and granted the amount of rupees 23,86,950 as compensation, which is not a just and a reasonable compensation. Then counsel appearing for the respondent insurance company submits that as far as Arkeshwara Enterprise is concerned, he has examined the employer, and the court has also considered the fact that for the month of January 2020, the income was 12,285. The salary is 12,285, and the accident taken place in the month of February. Just basing on a payslip which mentions the minimum wages of 16,221, the court had still considered, and as this is an accident of the year, so 2020 had taken 14,500. When it comes to the other aspect, that is with regard to the cooperative milk vending society, except placing the documents, none was examined. The court was right in not considering it. it is submitted that the claimant is not entitled for enhancement. Next paragraph. Having heard the counsels on either side, peruse the material on record. The court had taken 14,500 as income. According to the learned counsel, court has to consider his two incomes. One is from Arkeshwara Enterprises and the other is from the Milk Cooperative Society. Admittedly, from Milk Cooperative Society, he has not examined anyone. Court was right in not considering it. Coming to Arkeshwara Enterprises, though it is stated that he is earning 6,221, but the salary slip which is produced by him shows that for the month of January, it is 12,285. The court had rightly balanced it by taking 14,500, and even on that count also, no interference is called for. In that view of the matter, this court finds no reasons to interfere. Next.
Number 25.
My lord, I appear for the appellant, my lord. Kindly at 2:30, my lord.
Yes, 2:30.
Some other records are required. Negligence is involved.
It is file leading matter. It also on file. It will be there. Records will be there.
5th or 6th, I request.
Take it on. Let's have on
7th.
7th Thursday. Yes, Thursday. Yes, next at the request of learned counsel, the respondent on Thursday. This call this list.
List number 2. Cell number 1. Parted matter cell number 1. Dhananjay Kumar. For petitioner. Sudesh Kumar Acharya.
Yes.
Not responding, my lord, after the evaluation passing the interim order for modifying up to
Last
the.
time also they didn't come.
Yes, my lord.
Let's see.
It's only a paltry amount of 5,000 is there awarded.
Then counsel so far as they
It's
have
covered by judgments, my lord.
that they are also continuing to pay. It is submitted by the learned counsel for the, it is on 29/24. Then after that, when did it came? This is matter on 37. There is.
Fourth, my lord.
Huh?
Monday, try, my lord, so that it could be disposed of.
Yes.
Please.
Though.
It's covered by the
listed,
judgments.
As per, for dismissal, not part heard. This is, though there is no representation on behalf of the petitioner, counsel for the respondent is present. This is matter for dismissal on Monday.
Please, my lord.
Cell number 2. Cell number 2. Rajshekhar S.
Yes.
I may be permitted to produce the memo. Show that my lords have paid the additional expenses. She has employed also thereafter, my lords. That document also I have produced. I request my lords to kindly see my lords, the first document that is
So
for.
before going to the document,
Yes,
so again to revive the memory of the court.
Please,
Let's
my
go to
lords,
the impugned order.
there was a, under compromise, my lords, so decree came to be passed with an understand before this honorable court, my lords. So with an understanding that, my lords, I should pay the educational expenses which your lordship will get at page 25. 25. Relevant, my lords, is at page 26, clause D. Clause D, page 26, my lords.
You are for the husband.
I am for the husband. The respondent shall bear the educational expenses of both the children up to post-graduation level.
Either in India or abroad.
Or abroad. Thereafter, my lords, then I should pay monthly maintenance. What they do, my lords, they file execution petition, which your lordship will get at page number 28, annexure E. Kindly see the relief sought for, my lords, at page 29. This execution petition came to be dismissed. Then, my lords, they prefer MFA before this honorable court. That MFA also came to be dismissed, which your lordship.
The reason for dismissal of the earlier petition is
Yes.
about the future expenses.
Yes,
she's
now
done.
that is what.
Unless and until he's.
My lords wanted to know whether I have paid. Now kindly
Now,
see.
what is the present order? That I want to say.
No orders are, my lords, passed. Initiation of the proceedings itself is under challenge. On the ground that, my lords, already one execution petition came to be filed. I have complied with. MFA also came to be filed. That is dismissed. As again now, yes, please.
First execution is filed, is
Yes.
dismissed.
Yes.
Because the future expenses, she cannot file a execution.
On hypothecation,
That was dismissed. That was also confirmed in
confirmed
the
by
emergency.
this.
No, she has filed the second execution.
Yes.
So according to her, she has already spent the money on
Yes.
the
Yes.
on that
Yes.
education which you
Yes.
have to pay.
Yes.
That will be decided by the court. Why
But sir,
should we
now
look into?
unnecessarily I will have to face, my lords, the ordeal of the prosecution.
Unnecessarily, you have come to the court in 2022. Otherwise, by this time, everything
Lords,
would have been done.
now the moment I received the notice, my lords, there should be an end to the litigation. Unnecessarily, I should not be, my lords, targeted.
What should be done by the executing court should be done by the executing.
Now, I'm
High
not
Court
on
will
that
not
point.
interfere. High Court will
Now,
not.
now may I request, my lords, on the last date of hearing, wanted to know, my
Not,
lords.
no, I understood.
Yes.
But let the court decide it, because when you have questioned the maintainability of execution proceedings, this court is of the view that it is maintainable. So you tell the court that I have already paid the amount, no execution is required.
With that observation, writ petition may
Yes.
be disposed.
Where is order impugned?
Order impugned
Not
at
execution, where is that execution?
execution
Number?
petition is at annexure A, page 12, my lords. 152 of 2022. And order of issuance of notice is at page 16, annexure B.
Please come. The present writ petition is filed, seeking a writ of certiorari to quash the initiation of the proceedings and issuance of summons in execution case 152 of 2022 pending adjudication before the second edition senior judge and itinerant court at Mudabidri. Mudabidri. The facts of the case are the parties have entered into a compromise before this court in
3 MFAs were there. In 3 MFAs.
In MFA number 8638 of 2022 clubbed with MFA number 8639 of 2022 and MFA number 8640 of 2022. As per the terms of the said compromise, that is clause number D, the husband shall bear the educational expenses of both the children.
May I interrupt? Pursuant to compromise entered here, my lords, decree came to be passed.
Pursuant to the compromise entered into, a decree is passed. The terms of the compromise are, as per clause number D, the husband shall bear the educational expenses of both the children up to post-graduation level, either in India or abroad fully. And clause E says that the husband shall pay a monthly maintenance of ₹10,000 to his children and shall pay the maintenance to his daughter for a period of 2 years or securing employment, whichever is earlier, and to his son for a period of 3 years or securing employment, whichever is earlier. Thereafter, in the year 2014.
14. Execution 18 of 2024. I'm sorry, 2014. My lords, may kindly see page
No,
20.
I've seen it. It is old case number 18, new case number 29 of 15. In the year 2014, it is, she has filed execution 18 of 2014. It is renumbered as 29 of 2015, seeking, and the court had dismissed the said execution petition
Page 55, my lords.
that the decree holder has failed to prove that they are entitled for the claim made in the petition on the basis of the evidence and documents produced by them. And that was carried in appeal, and that appeal also came to be dismissed. Thereafter, the present execution, that is execution case number 152 of 2022 is filed, and summons were served on the husband. Questioning the summons and initiation of the execution proceedings, the husband is before this court. Learned counsel appearing for the husband submits that when already one execution petition is dismissed earlier and confirmed by this court, the second execution petition is not maintainable. It is not maintainable. The wife is coming up with vexatious petitions, one after the other. Though notice is served, and as such, this petition has to be allowed, and the execution petition that is filed needs to be dismissed. Next paragraph. Though notice is served on the respondent, there is no representation on where no wakalat is filed on behalf of the respondents. Next paragraph. Having heard the counsel for the petitioner, peruse the material on record.
Memo file. Today I filed memo document.
Today, a memo is filed with some documents to show that he has filed in his contingency, please record. in this contention. He has filed a memo before this court stating that the educational expenses are paid by the husband. Next part. Having got the counsel for the petitioner for a material on record. There is no dispute about the fact that earlier execution that is filed is dismissed. The only ground that is the only ground on which the execution earlier was dismissed is, as per the clause, the future educational expenses has to be borne by the husband, and the wife cannot quantify the same even before that stage has come, and she cannot seek for it. Now she is seeking the educational expenses. Just because the earlier execution petition is dismissed, that cannot be a ground that cannot be a ground to dismiss this execution. Now this memo is filed stating that he has already paid the amounts and nothing survives for consideration.
Children are already.
That the children have already attained
No.
majority. Even if even
They are employed.
are now majors and are employed. Now, whatever are the circumstances, that it cannot be said that the execution petition is not maintainable. Whatever the grounds that are available to the petitioner husband, it is always open to him to submit the same before the court. This court will not go into those aspects, and the same have to be decided by the executing court in that view of the matter.
May make one more request, including the maintainability, I may be permitted to, including the maintainability of execution petition, I may be permitted to discuss.
No, we have already said it is maintainable. I've already said it is
My
maintainable.
lord said I have to raise all the contentions before the executing
No,
court.
no, you cannot say, you have to contest it. You have to, you can't come to this court. That's what I said.
No, that's what my lord said, but we, including.
Now the petitioner, the petitioner husband has any grounds to say that it is not maintainable. He has to submit to the very same court.
Yes.
And the court will decide the same. In that view of the matter, this, the writ petition is disposed of, giving liberty to the petitioner to raise all the grounds before the trial court.
Great.
Cell number 3, VB Sidramaya for petitioner. Shankar K.
I'm for the respondent.
No representation for the petitioner. List this matter as for dismissal on Tuesday.
Great.
Yes.
4 for dismissal matter, cell number 4.
I'm appearing for the respondent. Previous date appearing, they have not appeared. The respondent.
This matter came up before the court on 23/7/2025. On the day when counsel for the respondent is present, there is no representation on behalf of the petitioner, and so matter is directed to be listed today under the caption for dismissal. Today also there is no representation. It appears that the petitioner is not interested to pursue the matter. Dismissed for non-prosecution.
Cell number 5.
This is a RPFC of 2023. This matter from 2023, it has come up before the court on 2 occasions. On the 2 occasions, there was no representation for the petitioner. Last, it came up on 24/7/2025. So far, notice also not issued to the respondents. And on the last occasion, when there was no representation, this matter was directed to be listed today under the caption dismissal. Okay, so today also, same order. Yes, next.
Cell number 6. Monisha NS for petitioner, Suyog Erande.
I appear for the petitioner, my lords. It's the petitioner husband is before this court, my lords, challenging the order of maintenance, my lords.
Where is the order?
Please, my lords. It is at page 99, my lords.
90?
99. The order starts from page, sorry, my lords, page 77, the order starts, my lords. Page 99 is the operative portion wherein 10,000 has been granted, my lords.
Is that page number?
Page 99, my lords.
I think something is wrong, but which is RPFC 173.
Please, 773 minutes.
100 is your declaration verification petition.
Sorry, minutes, there will be some confusion.
That's not the order.
Page 77 minutes, I'm sorry.
Is it in Kannada?
Kannada, my lords, I'm sorry.
Why you want to?
I'm sorry, but I will produce it once. Minutes, in the meanwhile.
Order copy is in Kannada, the impugned order is in Kannada, then counsel for the petition shall file the translated copy.
In the meanwhile, may I make one request? Husband files a petition for divorce matters. The wife comes up with a claim for restitution of conjugal rights. At the time of evidence, I myself concede merits. The husband himself concedes it, yes, I am ready and willing to take. On that basis, a decree for restitution was granted merits. My only one request is if this matter can be referred to mediation. This is a fit case where, because, and both are employed merits.
Parties are interested.
Please.
There is a likelihood of mediation. Party shall appear before the Bangalore Mediation Center. on-
Merits may be taken up before a Mangalore mediation center,
Bangalore
because
Mediation
parties
Center
are.
On
Please.
11th. 11th.
Please, motion.
7.
Cell number 7, Hanumantappa Haravi.
My lord, and for the petitioner, my lord, on 2 occasions, that this honorable court granted time to the petitioner argue the matter, my lord, since the file is misplaced, my lord. And
Oh,
then,
please argue.
Please. My lord, the petitioner is the
Please come to
husband.
the impugned order. Which page is the impugned
Annex
order?
L matters, Annex L, in execution case number,
Page number?
Annex L, my lord, this is in the court file, but as I'm misplaced in the, Annex L matters. Execution number, my lord, it is 2 of 2020. The wife has filed the application 125 CRPC, my lord, by taking maintenance against the petitioner responding in the court below. Without hearing so the petitioner, so the court below awarded so the compensation against the petitioner. Therefore, that order and challenge in execution, my lord, 2 of 2020. Annex L, my lord, page number wherein I misplaced file is not with me. Annex L matters. Execution 2 of 2020. Is filed another petition, my lord.
You have questioned an ex parte order of maintenance
Please, my lord.
in execution.
Please, my lord.
Hmm.
I don't, my lord. I have not heard in the matter.
Huh?
I have not heard in the matter, my lord.
Hmm.
When the time of the hearing, the 120 application, the petition not heard in the matter. They so much of court, the court has passed the order.
I understood that.
Please, please, please,
You have to answer a legal question.
please,
If your ex parte order is passed,
please.
you will question the ex parte order in execution. Is it permissible?
No, it is, once it is ex parte order, we can challenge it, such order. The ex parte order, we have right to challenge that order, my lord.
Before the executing court?
Please, my lord.
Please read the order, we'll pass orders. Read the order. Read the order.
Please, file with me. I'll read the matter, file with me.
Yes, please come. Agreed with the orders passed on a memo in execution 2 of 2020. The JDR is before this court. Okay. This is first one, WP 3025. The court in MC number 249 of 2018 in the IA have granted an interim order granting stay, granting the interim maintenance of an amount of rupees 5,000 from the date of petition till the disposal of the case. The later that came to be dismissed, thereafter the wife had filed this petition seeking execution. Land counsel appearing for the decree, the judgment debtor has filed this memo stating that the wife wanted to join the husband, and as such, the case was dismissed, MC was dismissed. Now, when an interlocutory order, when the maintenance is granted on an interim application, when the main petition itself is dismissed, nothing remains for consideration, and as such, this execution is not maintainable. The court, by order impugned, had dismissed the said memo on the maintainability on the grounds that the submission of the judgment debtor that the wife had agreed to stay for that reason, the petition is dismissed. There is nothing on record to show. There is nothing in support of the said submission. Then coming to the second submission about the maintainability on the ground that the main petition is dismissed, court gave a finding that from the date of the petition till the disposal, that is till this matter is dismissed, the wife is entitled. In view of the same, the memo is rejected. Next paragraph. When counsel appearing for the petitioner husband, appearing for the judgment debtor petitioner, submits that when the main application itself is dismissed, there cannot be any execution of the maintenance that is granted by way of an interim order. Further, the main petition is dismissed as a wife wanted to join the husband and she has not joined. Even on that count also, the execution petition is not maintainable. Next, heard the counsels on counsel for the petitioner. In this matter, so far notice the
Respondent, sir.
the notice is the respondent is served, but no wakalat is filed on behalf of the respondent. The trial court on both the submitted, the executing court on both the grounds that are raised by the petitioner has rightly held that there is no material to show that the MC is dismissed as the wife had wanted to join, and coming to the maintainability, that and the main petition itself is dismissed, the execution is not maintainable. Court had rightly held that from the date of petition till the case is dismissed, whatever is the amount, that is an executable order. Even on that count also, this court do not find any reasons to interfere. Accordingly dismissed. Take the next.
Dispose of, instead of
Dismissed.
Dismissal, dispose of, that's the dispose of, they're quite different. Dismissal quite different. Dispose of and something is so negative, the positive impact. Dismissal having the negative impact as well.
It is not, what is the order of the court is the order of the court.
You
cannot tell the court what it should be. 7.1, where is the impugned order?
This is annexure, literally, annexure D, my is. Execution, my lord, is the case number 9 of 2022. On the same set of facts, they filed the second execution, my lord. The wife has filed. Annexure D, my is.
There is no order in this case.
Please, madam.
There is no order in this case.
No, no, madam, no order in this case.
Just you are sought for execution, stay of execution. The relief that is sought in this writ petition is the issue a writ in the nature of certiorari, quashing the entire proceedings on an execution petition number 9 of 2022, pending on the file of the Principal Judge Family Court at Shimoga. The grounds that are stated in support of the case are that the proceedings in execution case number 9 of 2022 on the file of the Principal Judge Family Court of Shimoga are highly illegal and bad because on the same set of facts in execution petition number 2 of 2020 already stay is granted by this court subject to directing the petitioner to pay monthly maintenance at rupees 5,000 per month as ordered by the trial court by the order dated 10/2/2022. It was communicated to the Honorable Court submitting the certified copy in WP number 3025 of 2022. Misunderstood the order of the court and entertained second execution petition number 9 of 2022. It is stated that it is nothing but mockery of judiciary. Therefore, the entire proceedings in execution case number 9 of 2022 are highly illegal without jurisdiction. An inquiry is to be initiated in this matter because the matter was seized off by the court in WP number 3025 of 2022. Interim stay in force. Once again, the court below entertained second execution petition number 9 of 2022 on the same facts of it is null and void. Therefore, proceedings ought to be set aside. The execution petition number 9 of 2022 is filed. Seeking attachment and sale of movables, attachment of fixed deposit amount, and for also seeking arrest of the judgment debtor for an amount of for non-payment of the amount of rupees 80,500. Give that case, earlier case. The earlier execution petition, that is execution number 2 of 2020, is filed, seeking for recovery of an amount of rupees 55,000. That is for the period from the execution number 9 is for the period from 19/1/2020 to 5/1/2021. Whereas the earlier execution is for 18/3/2019 till 18/1/2020. This court is not able to understand how this execution petition is not maintainable. And the allegations are made against the judge saying that in spite of an order of stay in another execution, this execution is not stayed by the court. This petition as filed before the court is nothing but a pure abuse of process of law. A party when an order is staring at the petitioner husband, when he has an obligation to pay the amount, and without even questioning the order of maintenance that has attained finality in the earlier proceedings, comes up before the court stating that the execution is not maintainable, and goes to the extent of making allegations against the judicial officers that the High Court has to conduct an inquiry into this. For filing a petition of this kind, which is baseless, the petition is dismissed with a cost of rupees 10,000 to be paid to the Advocates Association. Next.
Case number 8.
My lord, regarding cost.
My lord.
What is that
petition?
Regarding cost, no payment. Because since already no employment, he has no in employment, Yes, cost is,
For that, you will not say that something wrong with the judicial officer, High Court has to conduct inquiry. When you're
Because-
writing the pleadings, you have to be careful, is it not? How can you make allegations? First of all, a frivolous petition. On the top of it, making allegations against the judicial officers.
well, already the stage, that's why they.
What connection it has? That
Because-
execution is for a particular period. This execution is for a subsequent period.
Well, in the meanwhile, the husband has filed the divorce of the petition of the regarding matter, the pending.
Yes, next matter.
Regarding waiver of the cost matter regarding I can leave sorry, the waiver of the cost matter regarding. Extremely sorry on this.
You have to be careful hereafter.
Please, make it. Next, the waiver of the.
Dismiss.
Please, great.
Next.
Cell number 8,
My lord's respondent.
Kumar, SK
Hearing for the
Pratima.
petitioner, my lord.
Hmm.
Lord, we had filed an application for interim maintenance.
Hmm.
We had sought for an amount of rupees 30,000 per month. My lord.
Hmm.
It was partly allowed granting rupees 6,000.
6,000 is granted.
Yes, ma'am.
Where is impugned order?
Lord, it's at Annexure A, page number 13 of the petition. Lord, the first petitioner is the wife. The second and third petitioners are the children of the.
Court has granted 6,000. What is the income of the husband?
Lord, admittedly, it's rupees 40,000 per month. It's a central government employee.
And the educational expenses are also directed.
Yes, ma'am.
How much are the educational expenses?
Lord, the exact number I do not
There
have.
are
it
two
right now.
children.
Two children, my lord.
How much
Father is paying 26,000 for both the children, 26 for both the children. Educational expenses are.
26. That is
in Chikballapur.
4 plus 5, 52. 52, that means per month almost 5,000. Per month 5,000.
Per month, apart from 6,000 loss, now he is paying 6,000 maintenance.
So 6 plus 5, that is 11. What is his income?
40,430. And he is a kidney patient undergoing dialysis. She knows that. I have produced all the records, my lord.
So the petitioner is a homemaker, my lord. She has no.
1 minute. So we'll increase it by another 4,000.
Milord, may I place whatever the decision, Milord, may I place all the records that he has been having medical expenses. In fact, para 16, Milord, may I just urge your lordship.
He's a government employee.
Government employee,
What
40,000.
is the medical reimbursement?
But he's not getting it. He's a kidney patient. Plus, I have, in fact, his brother is helping him. I have produced everything, Milord. In fact, I can produce it before your lordship also. Milord, para 16, Milord.
Yes.
Para 16, may I just, if your lordship permits, both
Yes.
parties have filed their, Milords will get it at page 38, 20, Milords.
Yes, I'm
Page
reading it.
Ink page. Both parties have filed assets and liability statement in the form of affidavits. On perusal of assets and liability statement produced by respondent at column number 5, it is stated that in the month of November and December 2022, a sum of 4,000 was paid to the petitioners for their maintenance. It is also stated that the fees of second petitioner was paid by respondent to the extent of 24,200 for the academic year 22-23. Further, on perusal of the records produced by respondent, the respondent appears to have been suffering from kidney problem. He has taken treatment continuously. Apart from that, the petitioner has produced medical records, which establishes that the respondent is undergoing dialysis every alternate day. Bank statement produced by the respondent establishes the payment made to the hospital. Further, respondent has produced bills, which conclusively establishes with regard to the amount spent for the medical
How much
expenses.
is spending towards his medical needs?
Plus, he spends a lot. In fact, his brother is helping him. May I be permitted to place all the records, Milords? I have no difficulty in that because I've done
No,
it.
you don't have to. No. Apart from records, you have to. You have to quantify what is the amount he's spending.
True. I'll
Then
date
once
maybe-
the respondent submits that the husband is a kidney patient, he is spending huge amounts towards his treatment, and the same will be placed on record. List this matter on 21st. It's in dismissal. Delete from dismissal.
Cell
Yes,
number
next.
9. Cell number 9.
Yes.
T. Sheshgiri Rao. Ravi R for respondent.
My lords, in this matter, I have no clear direction, so seeks for a short adjournment, lordship.
You have the file. What instructions you want? This is already posted for dismissal. You don't appear before the court. And when the matter is in dismissal, you can still ask for time. That's what is,
Kindly and next week, a
no,
short
please
adjournment.
proceed with the matter, pass on. Yes, next.
Cell number 10.
Hearing for the petitioner.
Tirupati
First
Ayya.
occasion at 23, the respondent misleaded this honorable court, misrepresented
Mm.
without mentioning the order passed by your lordship on 11/6/2020.
Hmm.
Then only because I was held up in court on number 9, I could not able to reach the court.
What is the order?
That is,
That counsel for the respondent submits that the petitioner
yes,
has
ma'am.
not complied with the
Not
interim
only
order.
your lordship order,
Mm.
the respondent suppressed where is the trial court or where she filed the application under section 23, 25(3) for execution. Herself he withdraw all the respondent 1, 2, 3. Suppression, I filed a memo along with the document before this honorable
I'm
court.
not able to understand what is suppression.
My lord, 11/3 it was not on
No,
23.
on 23/7, what is the order? Then counsel for the respondent
Counsel-
submits that.
Respondent
Petitioner has not complied
not
with the
complied.
interim
For
order.
this, your lordship heard the application.
Hmm.
Then your lordship passed on 11/6/2025.
Let's see that order.
Yes, ma'am.
This court is not inclined to pass any
Yes,
orders on
that is
IA number
instead
1
of
of
25, it was typed as 24.
Admit registry is record for the trial court records. Interim order earlier granted is extended.
Yes, ma'am.
What is IA number 1 of 22?
I want for the non-compliant to pay these maintenance to the children.
Anyhow, now the court will hear today.
Yes, I'm ready, my lord. I'm ready.
Pass over. We'll give an opportunity. Pass over. No representation for the respondent. Pass over.
Cell number 11. Cell number 11 for orders matter.
There is a letter. Give the letter.
Like instead of today, my lord, it could be tomorrow, my lord.
Tuesday.
Tuesday.
Tuesday, no representation for the respondent. Counsel the petition is present.
Interim order.
Delete from the caption for dismissal. The interim order earlier granted is extended till then.
Watch out.
June 2024.
But it was extended, my lords, on 20/12/24. It was extended, my lords, on one occasion by the coordinate bench.
No, it says on 16/1/2025, petitioner and advocate for respondent submits that High Court of Karnataka has called for conciliation
Yes, yes,
between the
it-
parties. Thereafter, on 29/1/2025, both the parties submitted that matter was set down for conciliation on 5/2/2025 and prayed for time. At a later date on 23/2025, petitioner prayed time stating that has fixed date for conciliation on 25/3.
Yes, yes,
So
my
3 months is wasted
Yes,
like
yes,
just
my
like that.
Yes, yes. But now, my lords, may I make one submission?
Arguments on interim applications were concluded on 3/5/2025. Both applications were disposed of through consideration dated 13/6. Parties to the litigation have been seeking time for cross-examination in pretext of ill health, either to the party or to the advocate representing. Their case is now posted for further cross-examination of PW1 on 19/6/2025. Has also directed his following cases by fixing the norms. For 3 months is for disposal of the main case or the interlocutory application?
For the main case, my lords, because it was, your lordship directed for 6 months. It was again, my lords, extended by the coordinate bench. My lords, it is still, my lords, at the same stage. Now, my lords, respondent evidence. My lords, one develop,
An order was passed on 11 June 2024.
My lord, may I make one submission, my lord? In this matter, my lord, the husband has made an allegation against regarding the paternity of the child, second child. For that, my lord, even in the cross-examination, he has agreed that, my lord, he is ready for the DNA test. Now, my lord, I have filed an application for referring the matter for paternity DNA test at the cost of the petition, because he is not coming forward to file any application for a DNA examination.
submitted
Now,
no
my lord, he
objection to
has
the
filed a
application.
memo.
I submitted no objection to the application.
No,
Day of June 2024. No, it is nothing on arguments. The court wants
Yes,
time,
yes,
I'm
ma'am.
granting time, nothing else.
please, my lord.
Yes.
No, because, my lord, how the proceedings are being conducted before the
2024.
court below, my lord.
Whereby this court had directed to dispose of the pending MC within a period of 6 months. The learned judge has addressed a letter stating and also stated how the matter couldn't be taken up from the month of January till the month of March, and thereafter also how on the ground that the parties are seeking time for cross-examination on pretext of ill health, either to the party or to the advocate representing them. And the court sought for another 3 months. A matter which was disposed of by this court in the month of
June 2020.
June 2024, 6 months' time has elapsed long back. After that, in another, again, time was sought. This is the second time. This court is extending time. This as sought by the court within 3 months without seeking any further extension. The court has to dispose of the matter. No further extension will be granted.
Bill number
Great.
12, Pallava R for petitioner, Prasanna VR for respondent.
Copy has been served to the respondent.
Counsel is there, yes.
Yes, my lord.
Argue.
My lord, kindly have the matter on next week, my lord. Some
Fine.
inconvenience today, my lord.
24 matter, now the notice is served. Notice is when after petition, no interim order. What is the stage of the MC?
It is the posture for evidence notes, I am told. Only 10,000 is awarded.
List is matter, finally on Wednesday, no further adjournment. Already the notice, the respondent is appearing. This is matter in B group. Yes.
13, Sangame, Somashekaraya RP.
My lord, advocate for petitioner, my lord. Because of pressure of work, not able to take summons, my lord, to serve copy of the respondent. Kindly hence praise time for 1 week, my lord.
Notice to the respondent. The petition shall pay the process within 2 days.
Cell number 14,
Default order.
the judge.
For the respondent.
Yes.
Serial number, yeah.
What is this non-compliance of office objections raised on IA number 2 of 25 for vacating the stay order, date not mentioned in prayer, based on memorandum of objection, affidavit not forthcoming.
I brought the verifying affidavit annexing to the objections to main petition. I am ready for the arguments on the main petition.
That you have to do it in the section, not here.
But
The
the
petition
thing,
shall
but
comply
the thing
with
is,
office
but the
objection
thing is, my lord,
within 2
there the
days.
petition is itself not
The
maintained.
office objections are complied with. List is matter
My lord,
on Tuesday.
my lord, with request, my lord.
Respondent.
As the matter, as the petition itself is not maintained.
That
May
we
kindly
will
heard,
see.
my lord.
That we will see.
As because wrongly abused both the trial court and the parties to the case.
Please come back, do whatever has to be done. And
And,
we'll hear it on
By
Tuesday.
2:30, I may make it speak, complain, my lord.
Tuesday. Yes. Next.
Number 15, hearing on interlocutory application.
My lord, it may be shown that respondent is seeking, respondent has to rectify. My lord said petitioner, please.
That objections are to be by the respondent.
Please, my lord, it's obliged.
Respondent shall comply with the office objections.
Obliged.
The office objections are complied with. List the matter on Tuesday.
Number one office objection is on the petitioner, my lord.
Interim order may be extended.
On you only, on non-compliance of office objections.
Objections of item number 2 and 3 is
First
on
is
the,
on you.
on the respondent, my lord.
There are some objections.
Very well, I will come.
Both the petitioner as well as the respondent shall comply with the objection. If the respondent's objections are complied with, list the matter on Tuesday.
interim order may be extended.
Interim order earlier granted is extended till. Yes, next.
Serial number 15, Rupesh Kumar S for petitioner.
No representation, pose this matter for dismissal on Tuesday.
Serial number 16,
For the petitioner, my lordship.
For the
Is
respondent.
in the continuation of delay application, my lordship.
You are for the husband or the wife?
Wife, my lordship. I am a 83-year-old. I am unable to stand and in trial court I have produced the medical record in exhibit P6, my lordship.
Let's
Hence,
see, before going into the condemnation delay
Yes, yes.
petition, we'll see the main, the impugned order. Where is impugned order? Impugned order is in Kannada.
in trial court, 7,000 rupees is impugned order in trial court.
Is it Kannada?
This is in Canada, my lordship.
Then what
I
to
will
do?
try.
You should have, when you're asking for a memo to post this, you should have get that translated copy so that we might have heard it today itself. When can you file?
Yes, my lordship.
When can you file?
1 week.
A week's time. List this matter on next Wednesday
Published.
for filing the translated copy of the impugned order. Yes.
serial number 17, discourse, serial number 18. For preliminary hearing, serial number 18,
Yes,
Krishnamurthy.
Mr. Krishnamurthy.
Petitioner's my lord. Lord, aggrieved by the case registered against the petitioner. and
Where is
for-
the order at what page number?
My lord, order is at page number 10, annexure A. Basically, the marriage was solemnized on 30/8/2013, and after the marriage, immediately after the marriage, the respondent number
Where is the
one,
impugned order? Page number I'm asking you.
page number 10, my lord.
Hmm.
Page number 10,
What is there at page number 10? What is the order?
I'm not challenging the order, my lord. I'm challenging the proceedings. It's a fall case registered against the family members of the respondent number 3.
Calling for the records in criminal miscellaneous number 36 or 2022. Under which provision this is filed? Quash criminal miscellaneous number. Under which provision all these reliefs can be granted by this court?
482, my lord.
482? This code is not having 482 jurisdiction.
My lord, 226 read with 482.
This code is also not having 226. It's only 227. All these can't be done before this court. Writ petition is not maintainable. Afternoon. Pass over.
Yes. Serial number 19. Sharat Gowda GB for
19
petitioner.
minutes.
My lord,
First-
the last night of hearing, they were
Yes.
instructed to file their statement of
Assets and liabilities, my lord. My lord's kind permission is ready, my lord. May be permitted to file it, my lord.
Why you do it when the
But I
matter
could,
comes?
he came today for a signature, man, only for that purpose.
Every time this is happening.
But that's
When we
me.
say
Please.
you have to file, you should do it
Please,
before
please.
the date.
My apologies.
Then
may-
counsel for the respondent submits the statement of assets and liabilities is ready and he will serve it on the counsel for the petition.
I'll file it today itself. my
This
lord.
is,
Please,
this is matter on 20th of August.
please, motion.
It's 20.
Serial number 20. 20. Chowda Reddy C for petitioner. Nalina K.
Appearing for the
Oh,
respondent, my lord, this
Honor-
matter is.
Okay, so actually I am the party in person. My advocate is unable to present.
Have you
today.
read this cost title, what is written?
Yes, yes, so I have.
No request for it. The no party is permitted to submit when the counsel is on record and all the advocates are. So you cannot submit. This is not a trial court. In high court, party can't come and tell that my advocate is not there, ask for time and all.
If I can get an adjournment for tomorrow because.
No,
here-
let your client, let your advocate.
One
come.
submission, ma'am. Kindly
Yes.
serve the copy of the writ petition, my lord. This matter is.
That you're saying when the advocate is not there, when the court is saying that he will not listen to him. Yes, this is for pass over.
Serial number 21. Serial number 21.
Lordship, this is pertaining to the period of expeditious disposal with
yes.
regard to a rural court, Your Lordship.
Report is there. Where is it?
Report. Statement. The principal civil judge.
Which year is going on now?
2022.
continue. 2018 or still pending, 19 or 3. This is which year?
January 2022. The petition was filed in 2022.
22. Not much matters. There are about 5. We'll say expeditiously, we'll not fix a time frame.
May some time be fixed, at least with regard to the application, Your Lordship?
IA will fix. IA will fix. The present writ petition is filed seeking 2 prayers. One is to dispose of MC number 33 of, where did you say about the IA?
Your Lordship, I is the first prayer. Second prayer is the proceedings, Your Lordship. Page number
Direction,
21.
The application, in this writ petition, 2 prayers are sought. One is to expeditiously dispose of the pending MC number 33 of 2022 and to dispose of the IAs that are pending for IAs that are pending consideration expeditiously. This court has called for a report, view that, about the pending cases on the file of the senior civil judge, Bangalore Rural. And as per the same, there are about 18 cases are pending, which are prior to 2022. And in the year 2022, there are another 20 cases are pending. In these circumstances, this court deems it appropriate to direct the court to dispose of. You should mention what are the IAs that are pending, not like what all IAs that are there, court will not decide.
We have actually annexed the IAs, only 2 IAs were pending.
What are the IA number?
Your Lordship, IA number has not been specified by the.
What purpose it is filed?
Modification of the visitation order, Your Lordship. Under section
Then
26.
IA that is pending before the court seeking modification of the visitation order that is granted on
7/11/2023.
7/11/2023 shall be considered by the court within a period of 2 months from the date of the receipt of the order. The main MC shall be disposed of as expeditiously as possible. The notice, this court is not proposing to issue notice to the respondent as notice expeditious disposal of the case is in the interest of both the parties.
Greatly obliged.
22,
Yes.
Petitioner is the wife and children, my lords. They have sought for enhancement.
Notice to the respondent.
Serial number for admission matter, serial number 23.
On filing of acknowledgement for having this.
We were paying the amount, my lord. Today also we are ready to pay 50,000. But the respondent not.
There is a counsel, NMOC.
Last occasion also he was absent, my lord.
Let's see. On 21/7,
Yes, ma'am.
2025 also, there is no representation on behalf of the respondent. Then counsel for the petition is present. Today also there is no representation. This is matter on 19th of August. Even on the date there is no representation. The court will pass orders on the merits of it.
Few matter may continue.
Tomorrow earlier granted is extended till then.
Great.
Yes.
24. H. Maltesh.
Appearing for the petition. Memo of the notation submit.
Take that. A memo is filed that the petition not want to prosecute the matter. Accordingly, memo is taken on record and dismissed as not pressed.
Serial
Yes,
number
next.
25. 25.
Appear for the respondent wife.
Kumar, Vijay Prakash.
What was the amount granted by
Lord,
the court?
this matter was heard last week. It was against an ex parte order passed under a proceeding
Hmm.
under 125 of the
Is
CRPC.
it that how much amount is ready to pay?
Exactly.
the
I
consideration?
want to make one clarification. This honorable,
Awarded ex parte
this-
is how much?
35,000 was awarded to the mother and child together, my lord.
Hmm.
And,
Your income?
Sorry, my lord.
Income?
Income, my lord, 1,40,000.
Hmm.
But there's a little background I wish to tell the court, apprise the court about. Lord, the allegation is in 2010, the marriage happened. 2011, the girl child was born. And 2012, she came to know that petitioner was earlier married and that marriage was still in subsistence. So she filed first for a nullity of marriage. This happened in 2012 before the principal family court at Mangalore. In 2014, my lord, that decree of nullity was granted, which was challenged by me in a MFA, which is still pending before the division bench of this honorable court. My lord, thereafter in 2022, throughout my defenses, there has been no marriage. Yes, I was married. I am married earlier also. That marriage is still in subsistence. I am with my wife, living with my wife. And there is a daughter from that marriage also. My consistent defense is this is not a marriage. This was only a relationship. Be that as it may, my lord, I'm not going into the merits. And in the MFA, my lord, I have paid 2 lakhs to her by way of demand draft on 11/8/2022. So it is incorrect to say
How much?
2 lakhs by way of a demand draft, which has been recorded by the division bench of this honorable court. So trial, my lord, I will not say. Now my lord would understand that it is an ex parte order and my only request would be to remand it back so that I can put forth my defense.
That you can put
Yes,
forth.
only
No.
question now, my lord, is how much I am willing to pay is what your lordship will look into now. Given the fact I have paid 2 lakhs to her and it is not that.
No. What we do is.
Yes.
Now, whatever amount we say, like you
Yes.
will be paying and arrears also at that time till that.
Till the disposal of the
till disposal.
125.
So, what you have paid in the 2 lakhs, that also we will count in this. But some amount you have, what you are
I
ready
will
to pay.
certainly, my lord, my submission is this. I am legally married and I have a child. I am the sole earning member. I have a earning of 1,40,000. 2 lakhs I have already deposited. They also know the same counsel appears in that matter also, MFA also. And given all this, my lord, your lordship could kindly reduce the per month. Your lordship had suggested 20,000 rupees per month from the date of petition, which would be to 2020 till date. It will become onerous for me, my lord. I mean, in one go, I may not be able to because
Strongly
I'm also.
opposed.
But let me finish, sir. I'm a salaried person.
No, we'll see. 1 minute. When was the application? When was the IA?
Not IA, my lord. Final, this 125 CRPC petition itself was filed in the year 2020.
2020.
And
which month in 2020?
somewhere in the 3rd month of 2020.
We are in 2025.
Yes.
So almost 5 years, 5 months.
Yes.
For 5 years, 5 months.
Your lordship would note, no notice was served on me. This was during the peak period of the COVID pandemic. My lord, in 2022, when we went for mediation, as directed by this honorable court in the MFA, that is when they came and told, listen, there's one more order against you under 125 CR. I did not even have knowledge of the order, the judgment in the criminal miscellaneous.
Even at 20,000, arrears would run into some 11 or 12 lakhs.
Please, my lords. There is a daughter, my lords. All along from now she is in 9th standard, my lords. Every year she has to pay the educational expenses. She has to take care of all her needs, my lords. The 20,000 which my lords had observed on the other day was, my lords, I should have bargained that it should be more, my lords. Now they are unnecessarily bargaining it to which 20,000. What is there in that, my lords? He is earning 1,40,000, my lords. Out of that 20,000, even 35,000 he can pay, my lords. What about educational expenses, my lord? Who is taking care of this year, my lord? She is 9th standard. Today morning, the wife has sent me the receipts, my lord. 60,000 she has paid, and brother has paid. She is unemployed, my lord. I am ready to file an affidavit that she is not employed.
What about the relationship of the child? That
Lord,
is also-
I am denying the child. Child is mine also. But to be fair, my lord, it is a matter for trial.
And these
But
things
having
have
said
already
that-
been decided by the MC court, my lords. Everything has been decided.
That
His
is
conduct
sub
has
judice
been
before
observed.
the
Everything has
division
been observed in the
bench.
judgment.
That is sub judice before the division bench. My lord, to be fair, I will pay something. I have already paid 2 lakhs. I will pay something.
Something, you have to
My lord,
say what
I
is
should also survive.
something.
My lord, it cannot be her intention to drag me to the street. Because what I'm saying is, your lordship would understand.
I understand everything.
My lord,
What I want-
not a document is submitted before the trial court to say that she's otherwise abled, has a medical disability, she has to undergo constant treatment. She's a qualified BE engineer, and she doesn't want to work. She has to work. Everyone has to work.
No, we are not, because you wanted an order to be set aside.
Exactly,
and
my
you
lord.
demanded. So you
My lord, in
can't,
all fairness, let me contest, and I will pay something. I'm not saying I will not.
No, what is that something? I
But,
can't write that.
at least your lordship would reduce it to 10,000
No,
from
we'll say
20.
that the petitioner will pay something. So on that something, the trial court shall
No,
decide.
my lord, I'm quantifying it. Your lordship will reduce it to 10,000 per month.
One thing.
But what about daughter?
This isn't the report.
Please, my lord.
We will, 10,000, the arrears at 10,000. He shall continue to pay 20,000 per month from prospectively.
That also is fair, because
There would come a lot of amount now.
May I make one request? In addition to that, let him pay the educational expenses also.
no, I am not in a position to pay so much, because I have a family,
He
my
has
lord,
to-
I have a wife
But
and child.
he is contesting,
And
contesting the
when
proceedings.
he does not produce
But
any
this is a case where, my
document-
lord, say fraud has been played on me.
Your
my
lord,
lord.
no.
After
Not when
marriage.
the matter is sub
Please.
judice.
The
Don't
agreed
say
with the
fraud.
order passed in criminal miscellaneous number 27 of 2020 dated 26th March 2022, whereby the court had granted amount of rupees 10,000 per month to the first petitioner, 10,000 per month to the second petitioner, 10,000 towards the medical needs of the first petitioner, and another 5,000 towards the educational expenses of the daughter. Altogether, the court had granted 35,000, and counsel for the petitioner submits that this order is an ex parte order, and during the COVID time, there were no notice was received by the petitioner. As such, he could not contest the matter. It is submitted that there is no marriage between the petitioner and the respondent, and he is also denying the fact that the child, he is a biological father to the child. And counsel appearing for the respondent submits that the wife is not in a position to bear the expenses of the girl who is in ninth standard, and it is a duty of the petitioner husband to take care of the same. While the trial court in the MC for annulment was dismissed.
Allowed, my lord.
Allowed. Her
All his
petition-
conduct was observed, and it was observed that he has suppressed the first marriage and married me, my lords.
While decreeing the MC for annulment of marriage, the court has recorded the conduct of the petitioner husband. It is submitted that if there are no reasons to set aside this order, next para, having heard the counsels on either side, produce the material on record. There is no dispute that it's an ex parte order. The court had granted an amount of rupees 35,000, and on counsel for the petitioner submits that petitioner is married to another lady, and they're in the wedlock, they have a daughter. He has to take care of the family and denying the relationship with the respondent. And as it is an ex parte order, and whatever are the contentions with regard to the financial capacity of both the parties and other things have to be decided by the court. And at the same time, the interest of the wife also needs to be protected during the pendency of the proceedings. In that view of the matter, this court is passing the following order. The order passed with so-and-so, dated so-and-so, is set aside, and the matter is remanded back to the trial court for fresh consideration. During the pendency of the petition, the petitioner shall continue to pay 20,000 per month. That is from today, and from the date of the petition, that is criminal miscellaneous, till today, the arrears have to be calculated at 10,000 per month, and whatever are the arrears, they have to be paid within
6 months, my lord.
That's on the, that is on the date of appearance before the family court. my
Not
lord.
6
This is-
months,
my
not
lord,
6
because
months.
it-
The amount shall be paid in 4 installments,
Please.
equal installments. The first installment shall be after 4 weeks from the date of order. And next 4 weeks, that is for today, what is today?
It is 31st,
31st. So it should be by
31st August.
the 31st August should be the first installment. Then by 30th September shall be the second installment.
Instead of 4 installments, 2 installments, he can pay it. my lord. He has-
30th,
Please.
30th
Be fair.
October, next installment. November 30th, the last installment.
Please.
There shall not be the petitioner, if the petitioner fails to pay this amount, the court shall consider the same and pass appropriate orders.
My lord, date may be fixed for appearance of parties.
Parties shall appear before the court when?
15th August, my lord. After 15th.
15th August. Your first time what you pay, that time you can.
Then 31st August.
1st September.
Grateful.
Shall appear, both the parties shall appear.
Grateful.
Yes. Yes, next.
Till number 26, CH-18, petitioner.
No representation on.
I'm
Yes.
waiting for the petitioner, my lords. I'm requesting for 1 week's time, my lords, because-
Why?
No, my lords, I'm representing the council, my lords. Council is having some medical emergency, my lords. She has informed me today morning.
The request of non
Please.
counsel for the petitioner lists the matter on 16th of September.
Please.
Yes.
Till number 27, Arun Govind Raj, petitioner.
Petitioner. The husband's petition challenging an order of maintenance, my lord, of the family court.
Dated.
Final order of maintenance, my lord, dated 28th October 2023.
Oh. No stay in this.
No, there's a-
My lords,
there
may
is-
kindly
there is-
peruse
there
the
is a
last order, my lords.
9/4/2025. There's an interim order.
Dated.
Dated 9/4/2025, my lords. There is a conditional order. My lords, the conditional order says deposit 50,000 per month as against 1 lakh, which was awarded in the original petition, my lords.
Within arrears also at
Arrears
50,000
at
within a
50.
period of 3 months.
My
How
lords,
much it comes?
my lords, it
45
comes to
lakhs.
50 lakhs as on today, but there is no compliance of the order, my lords.
Which means that the stay order does not exist. I'm ready to argue on merits of the matter.
My lords, if it is argument on merits, then I'll file my
First of
statement
all,
of
you have to
objection
comply
also.
with the interim order.
No, the interim order is passed on an application for stay filed by, I've come on record very recently. The interim order is passed on this, the stay order is granted subject to this condition. So the stay may not be, in my humble submission, if I have not complied, because my lord, I will point out to your lordship that the order is complete.
Things. No, either you have to comply with the interim order.
Yes.
Or you have to, you can't, no, because it's a conditional order, you have not complied, the execution has to go. So why would we stay the execution?
Look, I'm willing to make my submission on merits because 25,000, my lord, I have paid from 2009, from 2010, from 11/3/2010 until 28/10/2023, when the final order was passed. The interim order of maintenance was challenged by both the parties. 25,000 rupees, what was awarded by the family court. Both of us, my lord, did not succeed before this honorable court. That order became final. The family court now, while passing the order on 28/10/2023, increases the maintenance from 25 lakhs to 1 lakh, 25,000 rupees to 1 lakh per month.
So.
Retrospectively, my lord, from 2010. Retrospectively. I can understand, my lord, if the final order said from the date of the order.
No, what we do is.
Yes.
No, when is this criminal miscellaneous or MC? What is this?
Criminal miscellaneous under
When is
120
it filed?
It's on 11/3/2010.
2010, my lords.
11/3.
When was the IA filed?
No, IA for interim maintenance was filed along with the main petition. The order for interim maintenance was passed on 18/6/2013. 25,000 rupees per month from the date of the application, from the date of filing of the petition until disposal of the petition. That is the order. That I have complied with.
From 18/6/2013, when is the impugned order?
Well, subsequent to that.
28/10/2023.
You have paid 25,000.
That is complete. That's complied with, my lord.
My lords,
On 28/10/23, the family court goes behind the interim order which was passed earlier, interim maintenance, and says pay 1 lakh from 2010 onwards.
How is it generally? That's what is the order.
No, the concept is of section 24 and 25 of the Hindu Marriage Act. Interim maintenance pendente light is during the pendency of the proceedings. And post-trial, my lord, is from the date of the order, whatever the court finds has to be paid. Here, my lord, 25,000 rupees has been affirmed by this honorable court in proceedings filed by both the husband and the wife. Thereafter, my lord, that order very specifically said from the date of filing the application until disposal, this is the maintenance to be paid. And this final order, my lord, if at all, I'm also challenging the quantum. If at all, my lord, is to be affirmed, could only be from the date of the final order, could not have related back to the date of filing of the petition.
According to you, none of the orders will be passed from the date of petition.
Look, the interim maintenance, legislation now also speaks about interim maintenance. Interim maintenance, my lord, is from the date of the application. Section 125, no, it is not for interim. There's a provision in 125. So the second provision of 125 provides for interim maintenance to be awarded. The substantive provision of section 125 is for maintenance lifetime. That, my lord, in my respectful submission, the family court could not have gone behind the interim order pass and now directed me to pay from 2010 onwards. More so considering the fact that, look, I have placed on record, I was a captain in the merchant navy. My wife files a complaint under 498A against me. The police, my lord, sent notice to my employer and asked me when I'm on the ship to return to India for investigation. I am terminated within 2 months of the letter being issued by the police. The termination letter says, police have sent a notice, we cannot employ you anymore, your service stand terminated. Thereafter, I get a shore job in Bombay. I meet with a car accident, and because of the car accident, my lord, I suffer from epilepsy, post-traumatic epilepsy. All those medical certificates are before the court. But the court, my lord, goes into the income I was earning prior to the proceedings being initiated by the parties when I was working as a captain in the merchant navy. That situation changed 15 years ago.
My lords, these are the exhibits which are marked in the criminal miscellaneous petition, my lords. This is just for perusal, my lords. I have not filed my statement of objection. However, my lords,
can I have a copy?
These are all the exhibits which are marked. It's my statement of objections. I will furnish, my lords. It is not ready. Okay. A copy is there. My lords, I filed my statement of objections.
So what do you say? What is your submission on the point?
After the application.
Before you start, what his submission is that in the criminal, in the criminal miscellaneous, order should be prospective but not retrospectively from the date of petition. What is your submission?
For that, I will file my statement of objection, my lords. My lords may kindly see.
It's a legal issue.
Please. My lords, after the maintenance application was considered, it is the petitioner who approached this honorable court by filing a writ petition. Subsequent to that, the conduct is also recorded, my lords. I don't have.
No, we are on a legal point. Then we'll go further. Whether the maintenance has to be from the date of order in criminal miscellaneous or from the date of petition.
It is from the date of the petition, my lord. That was my prayer. Also,
in every cases that would be the what is generally granted in a final order.
Considering the capacity of the person, my lords, it is again the discretion of the court, my lords. Here, he is worth 400 crores, my lords. He has 18 institutions which run 78 courses of merchant navy. Everything is placed before my lords, my lords. Now she is a wife. She is with the father. Now she has a daughter to take care of. He is always, every time there is an order, there is an application filed before
these documents. What she's a passover. We will take it up in the afternoon.
My lords, afternoon I have a matter before Court Hall 1, my lords. It is
complete it and come and communicate to him because they're insisting for an interim order.
Please.
Disposed of in 2025 itself. This is matter on 16th of September.
What?
Next matter.
29 urgent, cell number 30.
Petition. Yes.
Prasanna Mia for petitioner Jagan Mohan Reddy.
Respondent.
24 application allowed and directed the petitioner to pay 10,000 rupees by
There is the order.
Lord, annexure A, my lords, the operative portion, my lord, is at page number 4. earlier, my lord, there was a proceeding on conjugal rights which came to be allowed and suppressing the
Pending delight from the date of filing of the petition.
Yes. My lord, earlier, my lord, there was a proceeding under section 9 of the Hindu Marriage Act instituted by the petitioner husband. That was contested and my lords came to be allowed on 11/1/2018 vide annexure B. She filed a petition for the court at Medicare. There my address was wrongly shown and she got a paper application. And on the order, direct petition before the public court. Company of the husband, my lord, the husband filed a petition for divorce under 13(1)(1)B. In the petition, my lords, she filed an application under section 24, contending that my lords, the petitioner is serving as a cabled operator and my lord, drawing salary of rupees 40,000. As a matter of fact, my lords, I have been serving as a daily wage employee and drawing the cable network, my lords. Assisted, my lords, it is pending, my lords.
So restitution is allowed.
Yes.
Restitution is allowed. She joined the company of the petitioner. For some time thereafter, he again started to harass this petitioner. So she has she has gone away to his parents, her parents' house. So she has not claimed any amount from that earlier petition. He has also not paid any amount. She has also not taken any steps to recover that amount. In this petition only, she has filed section 24. The trial court order is very clear, my lord. If any earlier he has paid, that should be deducted from this amount. That at page number 18, that order is there, my lord.
Yes. So now you're only on the legal ground, but
Yes.
because already restitution is ordered.
Yes.
Because she has been staying away from the matrimonial home without any reason. She's
Yes.
not entitled.
Yes.
She's not entitled is okay.
That is one of the ground.
Second,
And second ground, my lords, she has suppressed the material fact, filing of miscellaneous petition in the earlier round.
They should have
Though she
challenged the same.
contested.
They
That
should
will
have
not-
challenged the same after
we
the.
will not consider
Yes.
this.
On the other hand, she has not
What about the financial capacity? Come to that. Somebody has to pay, isn't it?
Even 10,000 very meager because
Example, he's having 15,000. Is a daily wage.
that should be proved by relying on documents, producing documents. Still not.
This is a MC of 2018. Order
Not-
is passed when 22. Then by that time, Rajesh versus Neha was there. Why you people don't do?
But there is an interim order of this on granted by this honorable court, directing me to pay a sum of 6,000 per month, Lord. Some amount, Lord, I have paid. Lord, I am told that.
No, there's
the rest of the
arrears
amount
of
has not
2
been-
lakhs, 2,16,000. Only 15,000 paid. Only in this month, he has paid only 15,000.
I will undertake.
He is not compliant with the orders of this honorable court, interim order of this honorable court.
We'll vacate the interim order then.
Lord, I will undertake to pay a some amount.
Not some.
Which,
Interim order is granted on a condition.
Yes.
Not some will not do.
yes, 6,000 Lord directed to be paid, Lord.
If you are not,
Yes.
because you are enjoying the interim order, you should pay.
Yes.
If you are not paying, we'll vacate the interim order. We'll hear it in the due course. Please get instructions from your client. If the interim order is not complied with, I'll vacate the stay by the next date of hearing.
Next date.
As
Lord.
per the
Till next
order
date.
passed by this